Now, we have divided today's class into, for two instructors into two different parts, a part 1 and 2, and then a part 3 and 4. Our first section is going to be handled by Emily, but we'll introduce Emily in just a moment. Our second section is going to be handled by Kerstin Henze from our Tampa office. So before Kerstin disappears for about 90 minutes or so, I would like her to say hi to everybody, introduce herself.
Hello, good morning, everyone. As Jeff mentioned, I'm Kerstin Henze, and I'm one of the partners and managing attorney of the West Coast office for the firm, which is located here in Tampa. So I'll be teaching parts 3 and 4 of the condo certification class, which will include budgets, reserves, meetings, both membership and board of directors meetings, as well as conflicts of interest.
Well, thank you very much. And we'll see you in about 90 minutes or so, almost a couple hours. And
Good.
before I introduce our speaker for the first half, I do want to mention there are no breaks for this. We know 4 hours is a long time. If you have to take a bio break, step away for a minute, just leave the class running, step away, do your thing, come on back. If your technology bumps you off, you lose your internet signal for a minute or so, just make the effort to come back in. Don't worry, it's not going to hurt you on getting your certificate. The Zoom sheet shows your timestamps in and out. That's what we use to cross-check with the evaluation a little bit later on, so don't worry about that either. So let's get started. Let me introduce now from our Pompano Beach office. This is Emily Gannon. Emily,
Hi,
it is all
guys.
yours.
Okay, Kerstin, you can go do some work for a little bit.
We'll see you in a
See you
bit.
later. All right. Hi, guys. My name's Emily Gannon. I'm one of the partners here at our Broward County office down in Pompano. I love Kerstin, so I love when we get to do these classes together. It makes me happy. I get to see her. All right. So as Jeff said, it's 4 hours. I know it's long. We have to. Don't get mad at us. We didn't create this. So I'm going to do the first 2 hours. It's milestone and CEUs, and then we get into election stuff and some records information and all of that. Most of this I think we can do fairly quickly. I'm going to try and keep us sort of under that first 2 hours, and then I'll answer any questions. So again, as Jeff said, keep your questions sort of till the end if you can. Try and keep them in line with which sections and which topics we're going through so that we can kind of stay organized here. That'll be the easiest way for us to take a look and actually be able to get you answers. We won't be able to answer everybody's questions, but again, we want to keep everybody moving along because 4 hours is a nice chunk of your day.
A big chunk of the day. And you want to mention, or should I, that anything you hear today, this is strictly educational in nature for your certification purposes, okay? None of this should be considered as legal advice, okay? So keep that in mind too, strictly educational, informational. And before everybody clutters up the Q&A with, hey, I'm here, can you see me? If you can see the Q&A, if you can type in the Q&A, that means you were properly entered into this webinar. No worries there. You'll get your credit. You don't have to let us know you're here, although we love seeing that you are. So thanks for joining us. And let me kick it back over to you now. Sorry for the interruption.
No, I'm glad you said that. So yes, again, this is all just general informational, educational material for you guys because you have to get these lovely certifications. So we're here to do that for you. All right, let's see if I can, the test. Let's see if I can screen share properly here. And then we'll dive in. All right.
All right. We'll get started. And folks, again, in the Q&A, good morning, everybody. You don't have to let us know you're here. It's all, let's reserve that for the questions a little bit later on. The fact that you can see it means you are properly entered. We're good to go. Emily, it's all yours.
All right. So you can see we're all set. All right.
Yep.
Okay. We're going to try and keep this kind of interesting, guys. I am originally from New York. Sometimes I talk quickly. Sorry. Again, it's a lot of talking today, so I'm going to try and do it fairly quickly anyway. Let's dive in. Okay. Topic 1. Like I said, our first topic is all milestone inspection requirements, structural integrity reserve studies. The big thing to take away from this is you're going to hear me say December 31st of 2024 about, I don't know, 200 times in the next hour or so. And we're in January of 2025. So I hope when I tell you these deadlines, this is not the first time you're hearing them, and that some of this for topic one is kind of old news for some of you guys. If you are brand new to the board, if this is really, you know, your first time taking any of these classes and sort of getting involved in the world of condominiums, then maybe this is new information. Hopefully your association is ahead of the game and this is not, this isn't going to come back to sort of bite you here. Because again, our deadlines, a lot of these deadlines have passed. So most of this first topic, again, hopefully is not new information to you guys and we can go through it and we'll have a little bit of an understanding already. All right, milestone inspection requirements. Let's dive in. What am I talking about? What's a milestone inspection? Like I said, hopefully this is not all brand new information to you guys, but a milestone inspection is essentially a structural inspection of the building. Really, they're looking at the load-bearing elements. All of this, let me backtrack for a second. All of this comes from, and I'm sure, again, this is not news to you guys, the tragedy of Surfside and what happened with Champlain Towers. And we don't want that to ever happen again, essentially. We want to make sure now that our buildings are safe, everything is structurally sound, that we won't have this crisis for another condominium. This is the premise of what we're getting into here. So when that happened, the legislature, you know, decided let's get some laws in effect that are going to prevent this from ever happening again. Let's make sure that the condominiums are being properly maintained. Let's make sure all of our buildings are structurally sound. That's really the impetus for this legislation and what we're going to be talking about for roughly the next hour. So with that in mind, with, you know, again, keep in mind that the whole mentality here, this comes from a place of we want to make sure our buildings are safe. We want to make sure we don't have this crisis tragedy ever again. Now we have to comply with some new requirements, with some new statutes, and we're going to have to do some work. So milestone inspections, that's the first part of it. We want to make sure our buildings are inspected. Let's start there. And an expert basically determines that they're structurally sound. That's the premise here. So a milestone inspection is really just what it sounds like. We're looking at, you know, the primary structural components, and this is going to have to be done by an architect or an engineer, or, and luckily they did expand this, they changed this to include basically a team of professionals under those architects or engineers, because when these laws first started coming around and first went into effect, and originally it just said an architect or an engineer with their certain professional licenses, there was a bit of a crisis in terms of, wait a minute, when we crunch those numbers of how many condominiums this applies to and how many architects and engineers there are in the state of Florida, we have a problem. The math isn't adding up. So now we've expanded it to their team of professionals, basically as long as the architect or the engineer will sign off, essentially. So again, the purpose for these inspections is to attest to the life safety, adequacy of the building's structural components. We want to make sure these buildings are safe. It is not, keep in mind, a milestone inspection is not to determine whether there are code violations. That's different. Now, those things may overlap ultimately, but that is not the purpose of this inspection. Now, who does this apply to? Do we need a milestone inspection? Okay, milestone inspections apply to any building that is three stories or more in height, and that's as determined by the Florida Building Code. Again, originally when this first went into effect, there was some confusion about, does that include, you know, a lower level parking garage? Does that include, you know, we're a 3-story townhouse, but the bottom floor is a garage? What is 3 stories essentially? And that was not clear. And so they did clarify it's as determined by the Florida Building Code. So again, your experts, your engineers, your architects are going to know what that translates to. But 3 stories or more, and that's in whole or in part. So you may have a community where, you know, some of the buildings are 3 stories and some are only 2, that sort of thing. But it's not going to apply to any purely commercial buildings. And then it doesn't apply when we're talking about single family, 2 family, 3 family. And they expanded it just this last year. 4 family dwellings are also excluded. Mixed use and condominium hotels, it's going to apply to them too, but it applies basically this is going to require some cooperation here, because the Residential Condominium Association and then any owner of the other portions, basically, of the building have to coordinate and cooperate here to get this done. And ultimately, the Condominium Association is going to be responsible for the portion that applies to them, the costs that are associated with their, the elements that they maintain. The initial milestone inspection. This is why I said these deadlines make me a little nervous for you guys, because now we're in January of 2025. When do we need a milestone inspection? Odds are you probably needed it done by December 31st of 2024. So, a little over 2 weeks ago, hopefully you had it done. Most buildings, most condominiums, that's the deadline. Essentially, the deadline is going to be December 31st of the year the building reaches 30 years of age. If you're in a newer building, that deadline maybe hasn't come yet. But that age is going to be based on the certificate of occupancy for when the building was issued. If your building reached 30 years of age before July 1st of 2022, which was the first iteration of this new statute, so before 2022, then your deadline is December 31st of 2024. So again, in South Florida, at least where I am, in Broward and, Palm Beach and Miami, most of our buildings are older than 30 years. And that was pretty much the deadline. After that, you have 10 years to sort of renew, so to speak. So every 10 years, you're going to have to do a new milestone inspection. Law enforcement agencies, your local government basically can have additional requirements. You may be forced to do it before 30 years, maybe 25 years. Broward County, some other counties and cities, I believe, have put in more stringent requirements where these milestone inspections are due earlier than the 30 years. So just make sure you're aware of what's going on and what your time frame is. Keep in mind too, those agencies might extend your due date, but that's not a given. You can't just say, well, we weren't paying attention and we didn't have the money and I don't know, we didn't hire an engineer in time. That might not cut it. It's a showing of good cause that you couldn't get it done by your deadline. And you're supposed to have already entered into a contract to do it. And then your architect or engineer basically has to indicate why that couldn't reasonably be completed by the deadline. All right. Milestone inspections prepared before July 1st of 2022. So again, the 2022 deadline or date is important because that was the first iteration of when these laws went into effect. The first time we had this statute to deal with, essentially. If you had an inspection report that was done before 2022, it may still comply with the milestone requirements. So in the world of, again, Broward and Miami, there were certain 40-year certifications that had to be done anyway. The counties required them. So if you had a 40-year certification done before then, maybe you had it done in 2021 for whatever reason. Maybe your building was, your building was born, so to speak, in 1961, and you had to have your report done. You did it in 2021. Okay, so your certification, that might still comply. That may still work for your milestone. You don't have to do yet another milestone. But again, speak to your engineers and talk to, whoever prepared that report for you and get that and make sure that would work with your local enforcement agency.
May I interject with one question?
Sure.
Because this is starting to build up here and it happens with every condo class. Does it apply, what we're speaking about now, do these apply to condominiums but less than 3 stories? They just want clarification. Like sometimes there's a parking deck underneath the first, like how would you answer that question for the multitude of
so
folks
it's
already
only
asking?
the 3 stories or more, guys.
Okay.
3 stories or more.
There you go. Thank you. I just see a few of them building up in there. Back to you.
And I know there are a lot of condominium buildings that are only 2 stories. Great. If you're 2 stories, you can, kind of not listen to me for a minute. But the milestone and the structural that we're going to get into in a minute, it's 3 stories or more. Okay. And then some exceptions, like I said, for those single family dwellings, that kind of thing. All right. Let's see. All right. So like I said, if you already had your certification done, you may already have a similar report that you can use and that would work, but you have to check with your engineer, you have to check with the local enforcement agency to see if that is sufficient in their, and meets their criteria, basically. They may have to look at the report again and maybe rephrase it or whatever, but talk to your engineer, that may comply. So we need a milestone inspection. Now what? Okay, if you need the milestone inspection, so again, you're a 3-story or more building, you need a milestone. The local agency is supposed to send you a written notice of this requirement. We've seen a lot of them. I know, a lot of the Coral Springs has been sending them out. A lot of Broward County things have been sent out to our clients. Again, I'm in Broward, so that's my frame of reference for the most part. Lots of local agencies are sending these notices out, and we're reminding the condominiums that these deadlines were coming up and that they had to get this work done. Once you get that notice, the board, once the association has that notice from their local agency, whether it be the city, the county, whoever it is, you have to notify your unit owners that you're required to do this milestone inspection. Now, a milestone inspection consists of 2 phases, and we're going to get into each one here. Phase 1, the simpler, easier phase, so to speak. This is where your architect or your engineer is going to perform a visual examination. Now, again, keep in mind what they're looking at and what their purpose here is. They're looking to see that your structural components are solid, safe, secure, all of that. So they may have to, it's a visual inspection, but they may have to access certain portions of the building and things like that. That inspection has to be done within 180 days of getting that notice from your local government. So basically 6 months. You have 6 months to get that done and get that report from your expert. Once that phase is completed, they will send that report to the local agency. Now, if they find no signs of substantial structural deterioration, and that's the phrase we use, substantial structural deterioration to any of the building components, we don't have to move on to phase 2. So if you're sort of all clear, no substantial structural component deterioration to these building components, we stop here. Phase 1 is complete. We don't need to move on to phase 2. We are done. Milestone inspection satisfied. Check the box. Good to go. Done. But I'm going to be realistic with you guys here. I don't know many architects or engineers that aren't going to find some signs of substantial structural deterioration, because they don't really want to, odds are, sign off on a report that says, yes, based on just a visual examination of your building, I think we're good to go. Your building is completely safe and structurally sound and all of that. And I'm going to sign my professional license, on that line saying that I believe that based on this visual exam. Odds are they're going to want to do a little more testing. They're going to want to move on to phase 2. So it'd be nice if we only stopped at phase 1, but my guess is they're going to be a little more thorough. And if I had to put money on it, almost everybody's moving on to phase 2. But here we go. Substantial structural deterioration, like I said, those are the magic words. That's what they're looking for. That does not include. So keep in mind, we're not talking about surface cracks. We're not talking about, some peeling of the paint, that kind of thing. They're really looking for a sign that, there's some weakness, something, a negative impact to the building's structural condition. So again, we're not the experts. The architects, the engineers are. Let them do their thing. If an owner tells you, hey, I see a crack outside, or I see some peeling paint on the building, it must mean our building is falling apart. No, that's not necessarily what it means. Obviously, you should investigate, but leave that to the experts. Let them make the determination here. So let's assume we're moving on to phase 2. Phase 2 basically is, again, required if we found any signs of substantial structural deterioration. Okay. This is going to involve destructive and non-destructive testing. So it's not just a visual inspection anymore. Now we might have to open up walls. We might have to, open up some concrete and take a look. I don't know. I'm not the architect or the engineer. They're going to guide you. Rely on your experts. Let them do what they need to do here. Phase 2, if that's what we need to do, it's 180 days after submitting the phase 1 inspection report. They have, and again, another 180 days to submit a report for phase 2. But at this point, it's really more of a progress report. It's probably not a complete summary. It's a progress report with a timeline indicating when they're going to be done. They do have to prepare an inspection report. This is going to have also a summary. That's important. We want them to have, and this was new, they have to have a summary in addition to the actual report. That's going to be provided to the association. That also goes to your local government. Minimally, this report is going to have the seal and the signature of the expert who did it, the engineer or the architect. And it's going to talk about what kind of testing they did, what the basis was for their various conclusions. It's going to identify those areas of substantive or substantial structural deterioration, and basically recommend any repairs that are needed, any work that would be done to treat that. They're going to identify if there are any dangerous conditions, any unsafe conditions, and if they did actually notice any code violations, things like that, they'll point those things out as well. After your milestone inspection, now what? So within 45 days of getting this report, the association has to distribute a copy of the summary. So this is why we said it was very helpful that they had to prepare a summary too. So it could be, a lengthy 200-page report, but maybe the summary is only 10 pages. And now you can sort of cut down on some of your mailing costs. Send a copy of the summary to each owner. Post a copy of that summary in a conspicuous place on the property. Publish the full report and the summary on your website if you're required to have a website. Local government, essentially, they can again sort of dictate how we're doing these repairs. They get to enforce it. Essentially, the repairs have to be commenced no later than 365 days after you've gotten the report. So you can't drag your feet. Once you get this report and you know what work needs to be done, get moving, get your experts, and start moving along on this. And also keep in mind that they're going to be watching now. They're going to review these reports and the work you've done and see if the building is unsafe for occupancy. And we don't want, we don't want your government, your code to come out and red tag your building and tell you everybody's got to get out, in the dead of the night. So hopefully that's not the case and you've been maintaining your building properly, but keep in mind, we want to make sure these repairs are being done timely. If you don't get this milestone inspection done, which again, for most people, we're 2 weeks past that deadline. The officers and the directors of an association willfully and knowingly fail to have the inspection performed. That failure is considered a breach of their fiduciary duty. So it's not a joke. So like I said, hopefully this is not the first time you're hearing about this, and hopefully you're already ahead of the game. We'll skip some of these. All right, let's get into the structural integrity reserve studies and the mandatory reserves. Now, structural integrity reserve studies, you're going to hear me just say SIRS from now on. And you hear some of the attorneys say SEERS. I say SIRS because it's SIRS to me. It's SIRS. But we're going to jump into that now. This sort of goes hand in hand with the milestone, but a little different. So you should be aware. And again, hopefully this is not the first time you're hearing it. What is the Structural Integrity Reserve Study? SIRS is a study of the reserve funds now that you need, because we want to make sure you have the money on hand to do the maintenance that we think you need to do. So milestone inspection was to make sure, we inspect and make sure everything's structurally sound. The SIRS is now, how are we going to be able to fund all of these repairs that the building needs? Okay. So this is how they're, connected. It's a study of your reserve funds for the major repairs. And essentially now they've added a new section of the statute that gets into more detail of what you need to be reserving for. These are all supposed to be related to the structural integrity and safety of the building. So it's all, again, structural safety. We want to make sure these buildings are safe. So there's a list here. You hear us call it little g sometimes because in the statute it's paragraph and it's sub paragraph little g. But this is this list. It involves your roof, the structures, fireproofing, fire protection systems, plumbing, electrical, waterproofing, painting. That's part of structure too. Windows and exterior doors. And there was some clarification this year too that now you're only reserving, we only care about the association having to reserve for windows and doors. if your documents require that the association maintain the windows and doors. Some buildings, some associations, that might not be the case. It might be the owners. And then you wouldn't have to reserve for it because it's an owner obligation. And then we still have this sort of catch-all that you had to have before. Any other item that has a deferred maintenance expense or replacement cost that exceeds $10,000. Okay. Or the failure of which basically could negatively impact the structure. So this is your little G list. Those are all the items we have to make sure we're reserving for and that we're doing the study for. Now, again, we're back to who needs to actually do this? Does this apply to me? Okay, so I'll say it again. Similar to the milestone requirement, this is for every condominium that is 3 stories or higher. That's it. So 1 and 2 story, no. 3 stories or higher. And again, that's as determined by the Florida Building Code. Same threshold requirement as the milestone, 3 stories or more, okay? Have to do these reserve studies, and it's at least every 10 years, and it's only residential condominiums, so not commercial condominiums. At least every 10 years, you have to get the study done. Now, there's some other exclusions, less than 3 stories, like we said, is not gonna apply, doesn't apply to you. And then single family, 2 family, 3 family dwellings, not gonna apply. And then any portion that's basically not part of the condominium, and commercial condominiums doesn't apply to them either. So what are our CEUs requirements? CEUs requirements, again, it's based on a visual inspection of the condominium property. So you can see how, again, maybe with your milestone and your CEUs, you can kind of work these together a little bit. It must identify each item that is going to be visually inspected. And essentially, again, it's a reserve study. So then we have to figure out the useful life, the remaining life of this item, and then the estimated replacement cost or the deferred maintenance expense, whatever it is. So if we're talking about a roof, okay, we know that the roof has 10 years left, and it's going to be and I'll just use a big, nice round number. It's going to be $100,000 to replace the roof. Okay, so we have to do some math. 10 years, $100,000. So $10,000 a year we should be reserving so that we have that money on hand. And that's essentially what this reserve study does. But we're focusing on these structural items. So the estimated life, and then we do the math. We track out how much, we're going to need for that replacement value, basically. Who's really doing this? Who's performing these CEUs for us? These reserve studies, and this is where we get a little more manpower available to you, if you will. So the visual inspection part can be done, again, by an engineer or by your architect. So again, if you can work it into sort of your milestone, great. Maybe they'll do sort of a 2-for-1 for you, so to speak. But also you could have a person certified as a reserve specialist or professional reserve analyst. And there's certain criteria there. It has to be by the CAI, Community Association Institute, or the Association of Professional Reserve Analysts. So there is a whole other group of people who can do these, and this makes sense because they're reserve studies. And these are the reserve experts, basically. So that's another option for everyone. The deadline to complete your CEUs. This deadline should not be new to anybody who's been paying attention for the last half an hour. The deadline to complete your CEUs is essentially, if you were existing before July 1st of 2022, December 31st of 2024. So again, that magic deadline, that was roughly 2 weeks ago. Hopefully you guys have already done this. If you were required to do it, again, if you fall into sort of a little exception, you might have some other time, but for the most part, December 31st of 2024. If you've had it done, or if you've had an inspection that would comply with this, if you had your milestone, or again, if you had a certification of some sort, a 40-year, a 50-year, whatever it might be, within the past 5 years, that may work for the structural integrity reserve study. You may be able to use that to sort of, as a placeholder. But talk to whoever performed that for you and make sure. All right, so once we get the CEUs done, where do we go from here? July 1st of 2024, now there's some notice requirements that have gone into place. Within 45 days after getting this study, now the association has to distribute a copy to every unit owner or deliver a notice that it's available for them to inspect and copy if they want. So you can send the actual the actual study out to everyone, the CEUs report, or you can send them the notice that it's available and they can come make a copy if you'd like. So you can save on some mailing costs there if you'd like. The other sort of requirement here, and again, we're already past the deadline, so hopefully we've done this. You have to send the division a statement indicating that you've completed this study and that it was sent to all of the owners and that you complied basically with all of your requirements. There is a form on the division's website. You have to go through there and send them that form. Again, hopefully we've done this, guys. You have to maintain those records for 15 years after that study is completed. If you have a website, it has to be posted on the website. What happens if you don't do it? We're in the same boat here. If the officers basically willfully and knowingly fail to complete their CEUs, it's considered a breach of their fiduciary duty. So they were really applying the pressure here. We want you guys to make sure you're doing this when you're supposed to do it. If the CEUs, all right, so like I said, essentially, if you're required to do a CEUs, 3 stories or more, now you have to actually follow it. So basically now you have to have the reserves that the reserve study is telling you you have to have. And those amounts, again, are based on these recommendations that expert gave you. You can adjust it a little bit. They allow for inflation, things like that. If there's a change in the useful life, maybe originally when the study was done, maybe you had it done, again, maybe it was part of some sort of certification and it was done a couple of years ago. And since you have taken whatever additional steps, you sealed the roof again. Oh, well, now there's an update. We actually don't have 10 years left on the roof because we did this extra maintenance. We have 15 years left on the roof. Okay, we can adjust the study accordingly and reserve appropriately. So maybe the amount now that we thought we needed has been reduced. So there is room to sort of work these things. There are some exemptions here for what you need to reserve for. Basically, if the estimate of the useful life is not ascertainable, if it's a useful life greater than 25 years, you don't have to reserve for the replacement cost, but you are still supposed to be reserving for costs of deferred maintenance. So keep that in mind. Now, waiving and reducing reserves, again, we're in January of 2025. So any kind of loopholes, exceptions, waiving of reserves that you wanted to do, odds are that ship has sailed now, but we'll get into it. For non-CEUs reserves, so your old-fashioned, traditional, regular reserves that are not from that list that I called the little g, so not that list of roof, waterproofing, electrical, all of that. Your regular old reserves, not those structural items. So maybe you have a reserve account for, refinishing the pool. Okay. That wouldn't be necessarily a CEUs item. So that would be a non-CEUs reserve. If you have non-CEUs reserve items that the statute, still required you would have because deferred maintenance over a certain amount, blah, blah, blah. You can still waive reserves for those non-CEUs items, and the vote is a majority of your total voting interest. So your owners would have to approve it, and it would only be non-CEUs reserves. Those are the only reserves that are available, so to speak, to be waived at this point in time. And you could provide for less reserves, no reserves, whatever it is. Members would have to approve that. You'd need a membership vote. Your non-CEUs reserves are probably somewhat limited now because most of your reserves, I assume, are probably those CEUs items. And now when we move into the category of CEUs reserves, guess what? Can't waive those. Have to fund them. Can't reduce them. Can't use them for another purpose. You are locked in. You have to fully fund these CEUs reserves now. The threshold was for a budget adopted on or after December 31st of 2024. You can't basically reduce those reserves. You can't waive them. So up to December 31st of 2024, there was an option. A lot of associations, a lot of boards were still able to waive for this year, for 2025, but it was because their budget was adopted before the end of last year, basically. But now, the way that statute reads, for a budget adopted on or after December 31st of 2024, can't waive anymore, can't reduce those reserves for CEUs. And that is the world we live in now. We are in January of 2025. So here we are. Now we're fully funding CEUs, okay? Now, what about using reserves for a different purpose? I think I said it in the last slide, same issue. You're locked in if we're talking about CEUs reserves. Cannot use them for another purpose, period, at this point. It's for a budget adopted on or after December 31st, 2024, but again, that's where we are now. What about pooling? Now, pooling gets a little complicated because, again, there's an issue of using funds for other purposes. If originally you had set up, or maybe last year you set up sort of two pools, a CEUs reserve pool and a non-CEUs reserve pool, then you should be okay. But at this point, that ship may have sailed. Don't, again, we were telling everyone, don't pool together any CEUs and non-CEUs because you can't mix those together. If you have questions about pooling or how your budget is now, talk to your counsel, because I know this is confusing.
I need to mention something real quick because this is building up too, Emily. Folks, I am typing questions for all non-attorney. I'm typing answers to questions for any non-attorney related questions that I can answer. I don't have the ESQ after my name the way Emily and Kerstin have it. So if you see me answering questions, they are not legal in nature questions. So folks, just keep in mind that that's the reason why a lot of your questions are not getting answered. They require an attorney to do so. And for those that came in a little bit later after the housekeeping at the beginning, there's 300 of you here right now. We're not going to get to all the questions, and some of the questions, some of them will be addressed after each section by each instructor. Okay. So please don't be offended if we don't get to yours. We're not going to get to all of them. The most important thing today in this 4-hour session is to cover all of the material you need for your certificate.
Thank you, Jeff.
Back to you.
All right. Yes, as Jeff said, we have to follow the rules too. We have to give you the information that we're required to give you so you guys can get certified. There may be, 4 hours is a long course, don't get me wrong, but obviously teaching you everything you need to know in the world of condos could take, I don't know, a
days.
Solid semester.
It could take days.
How long have I been doing this now and stuff pops up? Who knows? All right. Milestone inspection CEUs. All right, let's wrap up sort of this topic. Important to know too, your developer at the turnover, now developers are also required to do the CEUs so that sort of your new board, your new owners are not walking in blind. The developer has already sort of given you a foundation of what the CEUs is here. That's kind of nice that we put that in there. Now, another thing to be aware of, because again, this is a big change. Disclosures to prospective purchasers. This is now new. So each contract for the sale of a unit, a residential condominium, after December 31st of 2024 must contain certain disclosures, basically about now the milestone and the CEUs. And basically, if they don't have that correct language, if they don't have certain language, those disclosures in there, the contract could be voidable. So that's a big deal, guys. If you were not required to have a milestone inspection, then you can indicate why that wouldn't apply to you. If you were required to have it, that disclosure basically says we had it completed and here you go, or we didn't have it completed and here's the story. So certain disclosures now are going to be part of any contract for a condominium unit, a residential condominium unit, involving the milestone and the CEUs. So changing sort of the landscape of real estate as we know it now. Every purchaser who's entered into a contract is entitled, at the seller's expense, to get a current copy of that milestone inspection report and the CEUs report. Makes sense? Owners want to know, or, a prospective owner wants to know what they're buying into and what they're getting into here at the condominium. What are they about to walk into here? So they now get that version too, or get that information. If those reports are provided, the buyer's going to have 3 business days, because maybe they don't like what they see. They would have the option to cancel the contract. So this is important to know, guys, because again, if you're looking to sell your condo, be aware this is something now that may affect you, or to buy a condo. Any disputes regarding milestone and CEUs, and I say that only because, again, the way the condominium statute is, there's a certain term of disputes and how we pursue, again, disputes. Now we've included these things as items that could be addressed: failure to obtain a milestone inspection, failure to get your study done, failure to fund the reserves. These are all things that a challenge that an owner may bring against the association. That's most likely how it would come up. It would go through, pre-suit mediation potentially. Again, not sure how that's really going to play out, if anyone is going to bring any of these challenges. And it's interesting that it's really not going into effect until July 1st of 2027, that's going to be part of the statute. So I think they're trying to give us a little wiggle room here, but we'll see. Again, we'll see how all of this plays out, really. All right, so that's the milestone and CEUs portion. That was topic 1. Again, for most of you guys, I would assume, I would really, really hope that was not brand new information to you, because again, most people had a deadline of December 31st of 2024. So hopefully you guys, that was a little refresher, we'll say. So let's dive into topic 2, and then hopefully if I finish, an hour and a half-ish in, then we'll have some time to go through my sections before Kerstin starts hers. All right. All right, topic 2. Now we're completely switching gears. We're getting away from milestone and CEUs and all of the reserves and structural and all of that. Put that on the back burner for now. Now we're getting into sort of the typical everyday operations issues of the association: elections and official records. Fun stuff. We're in election season, guys, so you may have questions about elections, I would imagine. All right. When do we need an election? Basically, the simple answer is a vacancy on the board is caused by the expiration of the term, and it has to be filled by electing a new board member. That's typically how this all works. It's possible that there's a vacancy before the expiration of the term. Maybe somebody resigns, somebody, moves out of the community, or even worse, they're no longer with us. They can't serve on the board, whatever it is. Typically, if there's a vacancy caused for any of those reasons, because somebody resigned, somebody moved away, whatever it may be, the document's essentially going to allow probably the rest of the board, to then just fill the vacancy. They can appoint somebody. A majority of the board would just decide to do that and pick the person, and you don't have to go through a whole other election. Or alternatively, you could hold an election to fill that one spot. We have had some boards where it's a very clear divide. Maybe it's a board of 7 and somebody resigns, and they are 6 owners in a 3-3 deadlock, can't decide who that 7th person should be. I want it to be Joe. We want it to be Mary. We can't get a majority on either vote. So, okay, you could hold an election, sort of a mini election, and just, handle that one spot. Typically, the election is for the whole board. Not always, but typically. Now, elections are very regulated by statute, by the administrative code. Essentially, your governing documents may have a different procedure, but in terms of procedure, we're following the statute. We're following the admin code. Your governing documents, sort of, you can put them aside a little bit when we talk about procedure for the election. Every condominium is supposed to be conducted in this same way. So it's very regulated, very regimented, which does make it almost a little bit easier now. But first notice is going to go out no later than 60 days before the election. The association has to mail, deliver, electronically transmit a first notice. So your first key deadline is 60 days out from the election. If somebody wants to be a candidate, they have to return a notice of intent, notice of desire to be a candidate, whatever you want to call it. We just say notice of intent, typically at least 60 days before the scheduled election. That's your second deadline to be aware of. 60 days, 40 days, or 40 days. Is that right? Did I say 60 days twice? 40 days before the election. So that first notice goes out. It lets everybody know, hey, we're going to have an election on whatever it is, April 1st. And there's no way I've done that calendar deadline in my head. 40 days before then is the deadline to let us know that you want to be a candidate. And that's the notice, that's the deadline that any owner can submit their notice of intent. But that's a hard and fast deadline. If they don't do it by that time, they are not listed on the ballot. They are not going to be able to run. 35 days before the election. So there's a little window of time between when you have to send in your notice of intent. 35 days is before the election is the deadline to submit your information sheet. So if you want to be a candidate and you also want to submit an information sheet, a resume, whatever you want to call it, your CV, basically your campaign pitch of, hey, vote for me. You have a couple extra days to get that done. You have 35 days before the election to turn that into the board. It has to be one-sided, one sheet of paper, the 8.5 by 11. And then that's going to be included in the mailing, and that's going to go out with the ballots and all of that and with the second notice. Now, we get questions all the time. What if somebody puts on their information sheet, lots of slander and defamation and it's all libel and they're just talking trash about the board? That's not an information sheet. We don't want to include that in our mailing. Okay, I get it. I understand. The association can't modify those information sheets though. So you may have a cause of action against somebody who makes a false claim against maybe a board member or whatever it is, but ultimately the information sheet can contain whatever it wants. It should have their relevant information. Hey, I've lived in the community for 20 years. I'm an accountant. I think I could be a great treasurer, whatever. That should be in there. That's normally what's in your information sheet, but every now and again you get one of those other ones. But it has to go in the mailing, no matter what. Association can't modify it. Last notice, your second notice of the election and the annual meeting, is not less than 14 days and not more than 34 days. So 60 days for the first notice, 40 days for your notice of intent, 35 days before is that information sheet deadline, and then 14 days is the minimum for the second notice. So anytime between basically 34 days before, because you got to make sure everyone got their information sheets to you, and that 14-day deadline prior to the election, that second notice package can go out. Obviously, if you try and do it earlier, you give people more time to get their ballots and all of that, but the minimum is the no later than the 14 days before. So you may need that extra time to get everything organized and mailed out and all of that. So that's the second notice, and that's going to go out with the ballot, the envelopes, those information sheets. Essentially, your number of directors, unless your governing documents say something else, it's 5. If you're a smaller condo, 5 or fewer units, it's just going to be 3. Look at your articles and your bylaws to see how your terms are decided. Sometimes you can have a staggered term. You might have a situation where you're voting for 2 this year, 3 next year, and each person serves 2-year terms so that there's a little consistency on the board. You have the same 3, same 2, every other, whatever. But for the most part, look at your governing documents. That should outline it. Otherwise, we assume the term is just going to be a one-year term. Important to know, they added term limits some time ago, and they added a lot of confusion when they did it because it threw people off. You can't serve more than 8 consecutive years, and it's 8 consecutive years. So if you resign the day before the election after you've served for 7 years and, 364 days, could you be reelected? But important to know that now the question before was, well, when did that start? When do we count how long this guy's been on the board for 20 years? They've clarified now it starts from when they put this law in effect. So the math, so to speak, you start counting July 1st of 2018. So it's 2026 that we're going to really start looking at this. But there is still a way to be elected. It doesn't mean you can't serve more than 8 years, period. It really means 8 years unless you're approved. 2/3 of those who vote basically approve you on the board, or we don't have enough candidates. Makes sense. So either, people really, really, really need to want you, or we need you because we need a body. All right. Co-owners are not supposed to serve together. Now, if they own more than 1 unit, that's fine because again, they can serve as their individual, owner capacities. Or same thing, or if we don't have any or we have vacancies and we don't have any candidates. If we have the same number of vacancies as there are candidates, we don't have to have an election. We can just seat those people. So if we have three spots this year and only 3 people put in their names, great. We're seating those 3. We don't have to have an election. Important to note, because this confuses everyone, we don't have a quorum requirement when we talk about the election. So normally your quorum requirement's probably a majority. If you need to have an amendment, if you need to vote on reserves, if you need all these other things, we need to get quorum, we need to get quorum. For the election, you do not. For your election, you only need 20% of your eligible voters to cast ballots. Okay? So that's it. So once you get those outer envelopes, counted, basically, if you're a building or condominium of 100 owners or 100 units, and you have at least 20 envelopes from eligible voters, you're good. You're having an election. So we don't have to worry about the quorum portion. Official records, be aware you're keeping all of the election documents, ballots, proxies, sign in, all of that for 1 year from the vote. That's also if you're voting on other things, if you vote on amendments or again, reserves or something like that. Any challenge to the election process has to be commenced within 60 days that the results are announced. And that goes to the division. I assume you guys know that. A candidate means an eligible person who's timely submitted their written notice of intent. So now to be eligible, there are some criteria. There aren't as many as people would like from what I hear, because we get questions all the time. Hey, this guy has a violation. Can he still run for the board? Hey, this guy sued the association last year. Can he still run for the board? The only reason you would be ineligible or the only reasons are these handful of reasons, and that's it. Anyone else is going to be eligible unless they fall into one of these categories. So you have to be eligible at the time that notice of intent is due. So that 40-day prior to the election, that notice of intent deadline, that's the time you have to be eligible. If you're not eligible on that day, but you become eligible the next day, too bad, your name still can't go on the ballot. And that may come up in the world of one of these, which is if you're delinquent in the payment of an assessment due to the association. And it's assessment, it's not any monetary amount. So you can't find somebody and then say they can't be on the board. It's any assessment due. They're not going to be eligible. So again, if you're delinquent, but you didn't realize you were delinquent or you didn't realize you were behind, and you put in your notice of intent, and that deadline comes and goes for that notice of intent, and 2 days later someone says, oh, wait a minute, you didn't realize you're actually delinquent, we can't put you on the ballot, you may be inclined to say, well, okay, I'll pay you right now, I'll give you a check. It's not going to work. You have to be current, you have to be eligible on that notice of intent deadline. So if you miss it, you miss it. If you are interested in running, make sure you are current on that day. If you're suspended or removed from the division or by the division, you're not going to be eligible. If you've been convicted of a felony or an offense that is considered a felony in another state that would be a felony here, you're not going to be eligible unless your rights have been restored for at least 5 years. Again, typically we would not know that, honestly. Hard to know when someone has a felony conviction. If there's a criminal charge pending against an officer, forgery of a ballot, that's now a crime, guys. Theft, embezzlement of association funds, all these other things that could be crimes. They can't be appointed or elected to any association, and they may not have access to the official records of any association, except pursuant to a court order. So that's interesting. So if there's a criminal charge pending against somebody, that person cannot be on the board, cannot be appointed to any board of any association, and they can't get any official records. Voting by secret ballot. So like I said, when that second notice goes out, it sends a ballot. There's a ballot in there, and then there's envelopes in there. You may also have a proxy, but keep in mind, a proxy cannot be used in the election. You're not voting by proxy for an election. You might vote by proxy on, again, issue of reserves, issue of amendments, whatever it is. You return a proxy for quorum purposes, but you're not voting on the election by proxy in the world of condominiums. There is an actual ballot. It goes in an inner envelope, then there's an outer envelope. That outer envelope needs to have a signature of the owner or the voting rep. We have to verify all of that before we can count anything. So keep that in mind. Each inner envelope can only have one ballot. If a member is entitled to cast more than one, maybe they own 2 units, they have to have separate inner envelopes, but they could put that inside the outer envelope. Oop, sorry. So like I said, first step of any election is going to be verifying these outer envelopes. You know, basically you have an impartial committee. The board might pick some friends basically, or some, you know, some other owners that are there. They may appoint them. If you can actually have a full, you know, sort of formal committee meeting. You can do it where it's the same day as the election. It's open to all members. You're noticing it. It's 48 hours posted before, and they're not going to actually open any envelopes, but they're going to start verifying the envelopes and just looking at the outside envelopes, comparing to what's on the roster, making sure we have signatures, making sure we only have one envelope from each unit, those types of things. You can have that committee meeting same day, has to be noticed, and you can sort of start doing some of the legwork that you would do at the election. Otherwise, that's the first step of when you actually get to the election, and that can take some time. If you're a bigger community, if you're a big building, I've been at some of these elections where, you know, they start at 8 p.m. and we're not done till midnight. But if you start this first part, the commercial, you know, the impartial committee meeting earlier in the day and do it sort of as a 2-part meeting, then that might cut that down significantly. Fraudulent voting activities. We are not messing around anymore, guys. The legislature has made a lot of things criminal now, and we want to make sure the elections are done properly. There's no shenanigans, and there's no forgery. So a person who engages in any fraudulent voting activity related to an election, that's using threats, bribery, intimidation, any of those things to pressure someone to cast a ballot, not cast a ballot, whatever it may be, commits a first-degree misdemeanor. Again, we're not messing around. Forgery of a ballot envelope or a voting certificate that's used in an election is punishable as a 3rd-degree felony. Felony, guys.
That's,
yes,
yeah, that's quite an F word.
Yeah.
Yeah. How do boards check on potential board member candidates' backgrounds? So they can pay for those background checks, search online, that kind of a thing?
They're typically, that's why I said, you're not going to know. I mean, I'll be honest, you're probably not. You're just not going to know that somebody has a felony background and their rights haven't been restored for 5 years. I've
Okay.
seen it come up, I think, once.
Yeah.
So, you know, that one is in there to be in there, and you can put it in the notice and you can let people know that they're not going to be eligible if they fall into that category. But realistically, you're probably not going to know if they
Probably
fall
not.
into that category.
That's more of a scare them away tactic from the
Yeah.
beginning to hopefully not face the situation to begin with.
Yeah.
All right. Thanks.
So forgery of a ballot envelope or a voting certificate, I want to make that, you know, make a point of pointing that out again, because 3rd-degree felony is no joke, guys. And we've just had this come up recently where someone said, oh, my neighbor told me I can turn in her ballot because she's out of town, so I just signed it for her. No, you cannot do that. That's not, I understand why it seems like just a nice, friendly, innocent thing to do. Oh, well, my neighbor told me who she wanted me to vote for, so I just signed her name for her. No, again, not a joke. You can't forge someone's signature. That is a crime. So you can't think of it just as, well, it's a condominium election, so it's, you know, it's not so serious. No, it's serious. It's a 3rd-degree felony. Don't do that. Electronic voting, you guys now know, I guess since COVID, electronic voting has been very handy. It was rare before. It had just sort of come around. And now since COVID, a lot of associations are actually using it. There are more platforms, more companies you can use. I'm being told it's not as cost prohibitive as it used to be. So definitely something to consider. We won't go into all the nitty-gritty details of how to properly do your electronic voting, but just know that essentially if you want to do electronic voting, you have to work with a platform that does it properly, that knows what the requirements are. It's going to have to be something that the board establishes at a board meeting. It's one of those exceptions. It's a 14-day notice for the board meeting. The board has to establish a resolution that spells out that we're going to start electronic voting, and that indicates, and we're going to comply with all of the requirements and all of the deadlines and all of that. So it's not just, oh, we want to do electronic voting, so we're going to let people send an email. That is not what it is. It is its own thing with requirements, with precautions of keeping everybody anonymous, with verifications and all of that. You have to do it with a platform. You need a company to work with to do it. It's not just something that the board's going to be able to just say, okay, we'll let everybody email their vote. That's not what it is. It is more than that. So certain procedures have to be in place. Like I said, the administrative code outlines how this is going to work. But if the board is considering it, again, talk to your attorneys first, talk to some of these vendors, and make sure you're complying with all of the requirements. So again, the slides are here. You can look through them. We won't go through all the details. Some important things to know, though, the notice is going to indicate that the association uses online voting and what those deadlines are for the people who want to vote through the online system. If a unit owner is present, if a unit owner votes online, basically it counts as them being present towards quorum. So that's kind of nice too. Again, if you're voting on something like reserves or whatever, and you need to hit quorum, that's good to know. Let's talk about officers real quick. Essentially, unless there's something in your bylaws, the board is supposed to have a president, secretary, treasurer, and they perform the duties that typical presidents, secretaries, treasurers would perform in any corporation. Again, you're running a business, guys. This is a corporation. So it's not for profit, but it's a business basically, and probably with a relatively large budget. So keep in mind, you have a real obligation when you're on a board. Officers are going to be serving without compensation unless there's something in your bylaws that says otherwise. The officer positions, keep in mind, when you are elected to the board, you are elected basically to fill a seat on the board. Once that board is chosen, so once we have our 5 board members, now who's going to be in what officer position is up to those board members. So we'll have some owners sometimes come to an election and when I announce, our new board is XYZ, they'll say, I want Joe to be president. Can we make Joe president? Well, thank you, owner, for your, 2 cents. But ultimately, those new board members now get to decide if Joe's going to be president or Mary's going to be president or whatever it is. It's those 5 that get to vote and make those decisions in terms of officer positions. And they can change that at any point in time. Typically, the organizational meeting, which is where we decide what officer positions everyone is going to have, is held right after the annual meeting because we have our new board members. But you could reorganize, you can change officer positions at any point in time through the year at a normal board meeting, 48-hour notice. Maybe somebody doesn't have the time to be the president anymore and they let the other officers know, I'd like to stay on the board, but I can't be president anymore. Can we, reorganize? That's totally normal. There's nothing against that. You can change officer positions anytime. Fun little trivia fact, if you're on the board, you can't vote by proxy or secret ballot on board matters, except for the only time you get to vote by secret ballot is when you're deciding who the officers are going to be. Because again, sometimes at that meeting, it's a little awkward. Maybe we have 5 new board members and we're not sure, maybe there were some different contingents running. We don't know who's who, and we don't want to have to vote out loud by hand who we want the president to be. Maybe we want to write it on a little piece of paper instead and just hand it to the attorney and let the attorney announce it. You can be disqualified from serving on the board if you accept a kickback. Again, 3rd-degree felony. We're not messing around with these criminal charges, guys. A kickback is going to mean basically a service or anything of value where consideration wasn't provided from a proposed vendor or somebody who wants to provide goods or services to the association. So essentially, that whatever it is, you hear the stories of, well, the new President Joe just got a new roof because we're also doing the clubhouse and it's the same company. Okay, it doesn't necessarily mean he got a kickback, but it starts to smell a little funny and we want to make sure he didn't get a kickback. An officer or director charged by information or indictment for any crime outlined in that part of the section, or that section of the statute, forgery of a ballot, theft, embezzlement, all of those fun things, is going to be removed from office. So that's if they're charged, keep in mind. So if they're arrested, if there's an indictment, whatever it is, if they're charged, not necessarily convicted, charged. If the charges do get resolved without a finding of guilt, that officer could be put back on the board. So maybe it was all a big mistake. If an officer or director is more than 90 days delinquent in the payment of any monetary obligation due to the association, they're deemed to have abandoned their seat and they're off the board. And the board can fill that vacancy any way it wants. So this is good to know too, because this comes up a lot. If you are on a board, please make sure you are current. Please make sure you do not become delinquent and you do not fall behind. Don't pay late. Don't make partial payments. It gets very confusing. If you are 90 days delinquent and you are on the board and you become more than 90 days delinquent on day 91, you are automatically off the board, period. The board doesn't have to take any action. It is by operation of law. On that 91st day, you're out. You are done. So that doesn't mean on that 91st day, the property manager is going to call you and say, hey, you know, Bob, you owe $500. Your check bounced last month. I don't know if you realized, or whatever it is. Oh, okay, let me come pay. And now I'm back on the board. If the rest of the board wants to put you back on the board, if a majority of the rest of the board wants to put you back on the board, great. Maybe no harm, no foul, you're back on the board. But if they don't, maybe they didn't want you on the board and now somebody else can fill that spot. Be aware, more than 90 days delinquent, automatic, done, off the board. Now, some other sort of criminal things to be aware of, or criminal adjacent. A director who knowingly and willfully violates the official records inspection requirements, and I don't like this one, guys, knowingly and willfully violates the official records inspection requirements 2 or more times within a 12-month period, commits a second-degree misdemeanor, must be removed from office and a vacancy declared. Okay. This, to me, this was new, and a lot of attorneys in our area of practice do not like that this is in here either, because realistically, official records inspections, those requests often go through management. Sometimes there are, you know, some associations that are self-managed. Maybe the board is a little loosey-goosey on following the statute and complying and responding timely and all of that. And it's not intentional necessarily. There's no malice there. It's just, you know, stuff happens, they forget, they go on vacation, whatever it could be. But now it's knowingly and willfully violates the official records inspection requirement 2 or more times within 12 months. Commits a crime? I mean, it does seem dramatic. So we just want to make sure if you get an official records inspection request, address it immediately. Talk to your counsel. We don't want this to, you know, trip up any of our directors. And it counts for managers too. So it's a little scary. I don't love that this is in there, and I was really hoping it was not going to stay, to be honest. These other ones, if you want my personal opinion, I'm okay with these. If you knowingly or intentionally deface or destroy accounting records, essentially, you know, because with the intent of causing harm to the association, then it's a first degree misdemeanor. I'm okay with that personally. If you intentionally destroy some records because you're trying to hurt the association, I'm okay if we treat that as a crime. Great. Sounds great. Lovely. Now, if you willfully and knowingly refuse to release or otherwise produce association records with the intent to avoid or escape detection, arrest, trial, punishment, all of that, or you're assisting in the same type of behavior, that's a third-degree felony, and you must be removed from the office and a vacancy declared. Again, I'm good with that being a crime too. If you essentially, and these were put in the statute because I'm sure you guys all heard some of the stories in the last couple of years about these, you know, bad apple board members, so to speak, or even full boards that were doing some inappropriate things with their finances. It's all alleged, but there were actual arrests and there was, you know, money being embezzled and fraud and laundering and all of that. And then obviously when they got records inspection requests, clearly, if you're embezzling money and laundering money and doing all these things you're not supposed to be doing already, you're not going to comply with an official records request properly, and you're not going to give the right records. And I'm sure records were destroyed and all of that. So, because you got to cover up your crime, right? So that's why these 2 were put in there. And again, I'm good with those. I don't love the first stanza here that we have on this slide. I don't love that that was put in the statute, but again, my opinion doesn't really matter. It's there. You need to be aware of it. Make sure you treat an official records request timely and appropriately. And we're going to get into official records in a minute. A person who uses a debit card in the name of the association, you're not supposed to do that. But if you do, and it's for an expense that is not a lawful obligation, which means an obligation that was properly budgeted, reflected in the meeting minutes, all of that, then it's essentially, it's theft. So again, be aware, don't use a debit card. If a board finds that the officer or director has violated the conflict of interest requirements, they're deemed to be removed from the office. If you fail to timely file your written certification and your educational requirement, you're suspended from service until you comply. You're going to do that though, because that's why we're here, right? But just because you don't have that certification doesn't mean that if you voted, that doesn't void any board actions or impact any board action. So don't worry about that part at least. All right, websites, we'll get into that quickly. If you're an association that has 150 or more units, you have to have a website. That's been in effect now from 2019. So hopefully you already know that. They've expanded the requirements now. So now 150 or more units, that was in 2019. Now we have one more year, January 1st of 2026. You're going to have a website if you're 25 or more units. So it's going to be a lot of associations now. Basically, almost everybody is going to need to have a website. The website has to be this independent portal. You have to be able to give your owners a password so they can log in, and a login and a password so they can, there's a secured area for just your owners, basically. And I won't go through all the slides of everything that's required to be on there, but it's important to know, again, the website has to be protected. You have to give your owners usernames and passwords, and then all of your governing documents need to be on there, and many, 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 many other things that cover 3 different slides. So just read through these carefully, and we won't have to read through them right now.
Just going to say one thing, because we'll have
yes.
we're going to get the inevitable 27 questions about this.
Mm-hmm.
Portal and website for this purpose.
Oh yes, sorry.
Synonymous.
Jeff, you're the techie guy.
Synonymous.
Clarify that for them. Yes.
All right,
yes.
back to you.
And then we do have a slide. Look, it means you can even have an app.
Yes.
So it's essentially any, yes, website, portal, whatever word we want to use. There has to be an online way for people to get documents, basically.
Yeah.
That can be through an app, through whatever way. But, and there are lots of, again, companies now that will do that for you. Management companies are incorporating it into the services they provide often. So again, the resources are out there if you need your website set up. Official records. This translates into that or transitions into that pretty easily, because what's on your website? Your official records. But let's get into your official records. You have to keep official records. This is nothing new. All right. Now your official records, what are they comprised of? Again, long list. I won't read all of it for you. Basically all of your governing documents and your accounting records, your financial records, all of that. All of that is considered part of your official records. Now, the catch-all is all other written records not specifically included in the statute that relate to the operation of the association. So website requirements are one thing. Website doesn't quite mirror official records totally, but official records, now what you have to keep for your official records purposes, you should basically assume it's almost everything. It's almost everything under the sun. Written records not specifically included in the statute that relate to the operation of the association. So basically any written record that deals with the association, you probably need to be keeping it as part of your official records. Now, how long do we have to keep it? 7 years is sort of our guideline, but there are certain items that you have to keep forever and ever and ever and ever. That includes any plans, permits, warranties, anything that the developer gave you, a copy of your declaration, your bylaws, and any amendments thereto, articles, any amendments, rules, and then, so basically your governing documents and any amendments, and then any meeting minutes. That one was kind of new in the last couple of years, and that gives everybody some pause because we might not have meeting minutes that go back longer than 7 years since we just added that. But now you have to keep them forever and ever and ever, okay? Your CEUs and any inspection reports have to be kept for 15 years. which makes sense because you got to sort of re-up every 10 years. So you want to hold on to the old ones. Any bids for work, you only have to hold on to for 1 year after receipt of the bid. Any election materials, so ballots and really any voting materials, ballots, sign-in sheets, proxies, because it may not only be an election, and you might have another vote for some point, at some point in time for an amendment or something. Any voting materials related to a vote, you have to keep for 1 year from the date of that vote. Okay. Now, this was a new requirement. You need to be aware of this because this was new. It used to be, until last year, it used to be, well, you keep your official records in whichever way you keep the official records. We go to some older buildings where the system is, various filing cabinets or just boxes thrown in storage closets in different offices, XYZ, and it's a little bit of a free-for-all. Now, the statute actually says your official records must be maintained in an organized manner. Organized. That facilitates inspection of the records by a unit owner. So it's no longer, hey, we keep all those documents in some boxes miscellaneously labeled in this closet. Good luck to you. Nope. Have to be organized. If the official records are lost or destroyed or somehow unavailable, maybe your old board president moved away and took a box of records and never to be seen again. Okay. Your obligation now to maintain these official records also means you have to make a good faith effort to recover them. So that's another thing to be aware of because this is another new-ish obligation that you guys have. So you have to maintain all these records. They have to be organized. And on top of being organized, if you're missing any records that you're supposed to have, you are supposed to make a good faith effort to recover them, find them, possibly recreate them. I don't really know the depths of that, but now you're supposed to make a good faith effort to have all of those records that you are supposed to have. And it may not cut it anymore if you just say, well, the old president took a box of stuff and we don't know where it is. All right, inspection and copying. So the official records really come up in the world of official records inspections. After receipt of a written request by the board or its designee, the official records must be made available to an owner and the owner's authorized representative. And that's an and, not an or. So the owner and his or her authorized representative. And they changed that. That was a very distinct change to the statute too, because it used to be, an owner would come maybe with an accountant or maybe with their attorney. And we used to be able to say, well, it's just one of you that goes in at a time because it's owner or. Well, now it's owner and. So owner and their representative get to do this inspection. Within 10 business days of receipt of that request, and then the records also have to be within 45 miles of the condominium or the county in which the condominium is located. Renters have the authority now to inspect and copy, but only as to the deck, the bylaws and the rules, and then any inspection reports. So they don't have access to all of the official records. The association can comply with these inspection requirements if they have all the records available, great. Or, and this was nice, we got this sort of in our favor. If those official records are posted on the association's website or on the app or on their platform, whatever we want to call it, whatever magical word means documents or online somehow. If those official records can be found on the website or the app, the association can fulfill its obligation by just telling that owner, you can go to the website and get those documents. Here's the website information, go look there. And that's going to work now. So you don't have to say, come into the office. You can say, everything you're looking for is on the website, go there. So that's nice. And then you can also allow the records to be viewed in electronic format on a computer screen and then printed upon request instead of having, again, a conference room with boxes deep of documents. Maybe you have everything because maybe you're doing your website or whatever it is. Maybe you have everything on a thumb drive and you can let the person just come in and scroll through documents on a thumb drive. The right to inspect includes the right to make or obtain copies at a reasonable expense of that owner. If the owner wants to bring their own portable device, a portable scanner, or if they even want to just take pictures with their phone, we see that sometimes. Owners will just bring, their own iPad and just take a picture of a document because they're just looking for one thing or whatever it is. You can't charge for that. You didn't make the copy, they did. You can't charge for that. The association has to have adequate number of copies of the governing documents and any of the amendments, their question and answer sheet, year-end financials, that all should be available. They should have those copies. You can charge actual costs for preparing and furnishing the documents though, but have those things readily available. As of July 1st of 2024, this is another new thing that now you guys have to deal with as an association. So be aware, pay attention to this. In addition to responding to a written request and providing the access to inspect records, all of that, you have to simultaneously provide a checklist of the records that you made available for inspection and copying. You also have to identify any of the official records that were not made available. Again, this is a new thing that they just put into effect. So, and it also, the way they worded it was not great. It said simultaneous with the request. So it almost sounds like if someone sent you an email right now and it said, I'd like to come in and inspect the records, I'd like access to the records, that you would have to immediately respond to them and say, here's a checklist of what I made available to you, or what I will make available to you. You can come in tomorrow. It's strange, but so practically the way we've interpreted it is the checklist should be exchanged when you're doing the inspection. When the person comes into the office, you can hand them the checklist. Here's everything I made available to you, and a list of anything that you didn't make available to them. And it may be that you may not know what you're missing, so to speak, but if an owner specifically asks for minutes of the October 15th, 2021 board meeting, and there was a meeting on October 15th of 2021, but for some reason you can't find those minutes, then you do know, and you can list that on the checklist. We don't have the minutes of the October 15th, 2021 board meeting. That was a record we did not make available. Now, again, once this is pointed out to you, you should really be trying. You are supposed to be maintaining these documents now. You should be looking for them. You should have a good faith effort to recover them. So hopefully you're not missing a lot of documents, but this is a new requirement. So be aware, talk to your attorneys. Maybe there's a form they will give you. We've prepared one for a couple of clients for these inspections. If you give this checklist pursuant to this requirement as part of the official records inspection, it creates a rebuttable presumption that you complied with your obligations as the association. So something everyone needs to be aware of. You can adopt rules about official records and those inspections regarding the frequency, the time, the location, the manner, all of that. You can limit it so you can't get a million official records requests, back to back to back to back. We all know those owners. So maybe you want to get some rules in effect, but ultimately you're not going to be able to require a proper purpose or a reason for the inspection. You can't say, well, I don't know why Mary wants to see the minutes from the October 15th, 2021 meeting, so I don't think she should see them. That's not how it works. If it's part of the official records, they can see it. It's none of your business why they want to see it or what they want to do with it. There are going to be official records that you have to keep, but they are not accessible to owners. So basically they are not open for inspection, would not be provided, would not be given access to any of your owners, but they're still official records that you have to have as the association. You have to be keeping these, but they are not open for inspection. That is this whole list here. So any attorney-client privilege documents, those are not going to be open for inspection. Any information that you get in connection with the approval of a lease or a sale of a unit, that's important because often you do, if you think about it, you do run background checks. You might have, credit reports. You might have social security numbers, birth dates, sensitive information. Owners should not be able to see that, their fellow owner. Criminal records, whatever else. No. Personnel records of your management, of any management company, your employees, whatever it is, those are not open for inspection. That's different than the management agreement. The agreement, the contract you have with your management company, that's open for inspection. Owners need to know what they're paying for. but not your personnel records or those managers' information that way. Medical records, those are not going to be open for inspection. You might be saying, why in the world would we have any medical records of our unit owners? I'm guessing you probably have a couple owners that maybe had some emotional support animals or assistance animals, and they probably gave you a letter from a doctor, something like that. That would be a medical record. It's possible you have medical records. Make sure those are kept protected and those are not open for inspection. Some other things too. Now, this is important too when we talk about email addresses and addresses of unit owners, things like that. If those are not provided for notice purposes, they are not open for inspection. So you can distribute a directory if you wanted to that has unit address, telephone numbers, names, all of that. But an owner should be able to exclude their information if they don't want to include it. If this information is ultimately disclosed, the association is not liable, but just be aware. An owner can consent to disclosure of more information if they wanted. If they want to provide additional email addresses or whatever else, that's fine. Make sure the information that's posted on your website, that if there is, again, information that is not open for inspection, that information is not available on the website too, that you can't see it on the app. So if there's information that is not open, if there's something that has personal information, again, a driver's license number, social security number, whatever, make sure that information is redacted before you post anything on the website. The association's not going to be responsible for the misuse of that information if an association member comes and does the records inspection and then does something inappropriate with it. We've seen it time and time again where, delinquency reports, AR reports, those things are open for inspection. Owners can know if their neighbors are basically delinquent and haven't paid. And sometimes that makes owners very mad when they see that, Mary just bought a new BMW, but I see Mary hasn't paid the association in 6 months. And maybe I'm so mad that I post on Nextdoor or I send out a memo or I hand out a flyer to all of my neighbors and say, did you know Mary hasn't paid in 6 months? And did you know Mary owes the association $5,000? Whatever it is. Now, Mary may have a cause of action against that neighbor because obviously that is not okay behavior. But just because that information, that 6-month delinquency information came from the association, because this person did a records request, the association's not going to be liable for any of that. That's going to be between those owners. Attorney-client privilege, like we said, that's something that you have to be careful about. Now, there's a whole statute that outlines really what's protected, but basically anytime you're consulting with your attorneys and they're giving you legal guidance, legal strategy, litigation strategy, those types of things, that should not be open it's not open for inspection, and it really shouldn't be disclosed to your owners. That privilege can be waived by the board, but don't do it, guys. There's no reason to do that. Do not be sharing what your attorneys tell you, and do not be giving any opinions and things like that. That's, again, my editorializing here, but not open for inspection. The board could waive it. Only the board can waive it. Be aware. Now, what if we don't provide the timely access? What happens? All right. 10 business days. You have 10 business days, right? That creates a rebuttable presumption that you willfully fail to comply. And really, you should be offering an appointment within that 10 business days. Then you can offer some appointments outside of that window, but it's really not just respond within 10 business days. Provide the access within 10 business days. So make an appointment, at least an offer of an appointment within the 10 business days. If an owner is denied access, they're entitled to actual or minimum damages. It's $50 per calendar day, up to 10 days. Starts on that 11th working day. Not a lot, but still enough for owners to pursue potentially and come after you. Now, again, be aware of this whole, if a director or a manager knowingly, willfully, and repeatedly, which is 2 times in a 12-month period, fails to provide access, it's a 2nd-degree misdemeanor and they're removed from office. So these official records requests are not to be, treated lightly. Pay attention to them. Make sure you're dealing with them timely. Okay. Other official record offenses, we talked about these already a little bit. If you destroy records, if you refuse to provide records, because again, you're hiding another crime, it's a crime. Return of official records. This is important. We are in election season, so boards are going to be changing in the next couple months. If you're an outgoing board member or committee member, you must relinquish all official records, property of the association that you have in your possession, in your control within 5 days after the election. An outgoing member who willfully, knowingly fails to do that is subject to a civil penalty imposed by the division. So you can't just sort of, pout and say, well, I really wanted to be on the board. I was a great board member for so many years. I can't believe they voted me out. And I hate the new board. So I'm just going to hold on to these records that I happen to have in my possession. I don't want to deal with them. So I'm not giving it to them. Not going to fly. You have to turn the stuff over. Oh, an hour and a half. I did it. Okay.
You did. You did. Great job. It's a lot of talking.
It is.
While you're going through some of the questions, we're not going to address them all. We want to try to get everybody out of here at a reasonable time. Emily's going to look over a handful of them.
Yeah, let me see.
And while she's doing that, I just want to reiterate to everybody that yes, the slides will be available. A lot of you are asking that. Towards the end of the webinar in the chat area, not to be confused with the Q&A, but the chat area, hit the chat button so that the chat interface simply appears on your screen. It will say chat is disabled. That just means you can't send stuff our way via the chat, but we can send stuff your way via the chat. That's where we're going to place the evaluation link a little bit later. So I'm going to type the word test in there right now, just so you can see the chat area. That's, if you see the word test, you properly have the chat area open. That's where we'll place the link later on. This course is also being recorded and will appear on our firm website within a couple of business days under the resources tab. And I think that's the end of the techie questions that I had here. And oh, one other thing, Emily, if I may. A couple of folks in the Q&A alerted me that you're watching with other people. Folks, we plastered this just about everywhere we could, including the registration page where it says that you must register on your own and use the link that was provided for you after you registered to join the class. The division is very hard on us. We must have everybody coming in with their own unique links that they received after registering. That is in essence the sign-in sheet. That's how we know it's actually you. If you are watching with somebody else and are not using your link, we're not going to really know if you signed in or not. And that's what we need. Please do not put us in the position to fudge the truth for your association. And of course, for our firm, we will not do that. So you must register on your own and use the link you used that you received after you registered. Emily, back to you. You want to address a couple of questions before Kerstin takes over?
Yeah, some of these guys, I see that people are asking very specific questions.
Yeah, a little too specific.
Right, that really honestly we can't get into in terms of the nitty-gritty about what's in your inspection reports and what's in the CEUs and all of that. Really, you got to talk to your experts on those things. Elevators are a non-CEUs item. Again, talk to your experts on that. They're not listed in that little G, I can tell you that. But again, you want to talk to them about how they're specifically listed anyway. Let's see. Questions about pooling reserves. We talked about that a little bit. Talk to your attorneys, because again, now we're sort of past that magic December 31st, 2024 budget has to be adopted by deadline in terms of funding reserves and waiving reserves. So talk to your attorneys on how you want to do that, if you're able to do it now or not. Let's see. Can we simply change the number of board members? Well, Grace, that comes completely out of the blue there, it seems. But your board members essentially are going to be, again, outlined in your governing documents. It should be in your articles or in your bylaws. Otherwise, if there's nothing there, it's going to be 5. Typically, in terms of changing the number of board members, there should be something there, either a board vote, an owner vote, whatever it is, or you might just be stuck with a fixed number. But that's going to be completely dependent on what's in your governing documents. A little bit about the 8-year cutoff. If there are open seats, can the board member serve more than 8 consecutive years? Yes. So like we said, if there's a vacancy and nobody else wants to run, they can stay on. But that 8-year math, we're looking at it from 2026, really. That's our magic 8-year there. If a candidate doesn't submit an information sheet, are they excluded? No, the information sheets are optional. We have a lot of elections where nobody turns in an information sheet. They have to just turn in a notice of intent by that deadline, that 40-day before the election deadline. Some written notice of intent. Typically, we give them a form, but it doesn't always have to be on that form. They can send an email. They can anything basically written indicating they want to run for the board. Let's see. Can a renter of a unit run for a board? Good question. Potentially. Depends on what's in your governing documents. Statute doesn't say you have to be the actual title holder owner, but your documents might require it.
There are even situations where non-residents have been board members, right?
Mm-hmm. Mm-hmm. And we do have some long-term tenants who want to get involved. They've lived in the community forever and they want to be on the board. Why not? Again, as long as your documents allow it. Let's see. Similar question. If you're not on the deed and you submit a candidacy notice, is that fraudulent activity? Well, now if you're misrepresenting yourself as an owner, that's a little different. If you're running as a candidate because it doesn't require ownership, wouldn't be a problem. So you'd have to look at all of that. Someone had a question about, could we expand the size of the board to avoid an election? Again, all depending on what your governing documents allow. We've seen that before too, where all of a sudden more owners want to be involved and the board says, okay, we'll go to 7 instead of 5 this year. And if that's allowed in their governing documents, great. And then we don't have to have an election and we can, cut to the chase. Let's see. Somebody asked about being disqualified from the board. If you miss 3 or more regular meetings, do you lose your seat? That's not in the statute. There's language in theory that you could put in your documents that maybe you've resigned, you've abandoned your seat if you don't attend X number of meetings or whatever it is. That is in some governing documents, but talk to your attorneys about what the situation is there and then look in your governing documents. Let's see.
I want to take one that's often confusing to people that's not legal in nature. Person's asking about official records on the website, which you already covered all that they can be on the website instead of paper copies, that kind of a thing. But downloading and uploading are 2 different things. So you would be uploading files to the website and then owners would be able to download them. So uploading them is management placing them on the site. I just want to get the language proper, similar to the whole parcel confusion.
Yeah, again, Jeff is our tech person. He's better with that than I am, for sure. Let's see. More questions about sort of who's eligible. Oh, and this is a good question. I should have clarified this too. Somebody asked about reserve issues for condos that are less than 3 stories. So if you are less than 3 stories, so again, less than 3 stories,
right?
We're not talking about milestone. We're not talking about CEUs. You are just back in the days of pre-2022 where, the statute was what it was and it hasn't changed for you. For you, it is the same. So you're still going to have to reserve for those items, the roofing, the paving, paint, what did I miss? And then anything over the $10,000 deferred maintenance.
Yeah.
Those are still your requirements. Those have not changed. You just don't have these additional requirements with the structural and all of that. You can still waive, partially fund, but the voting requirement has changed in the last 2 years. So it's not a majority of your quorum that's voting to approve waiving those reserves. Now it's a majority of everybody. So that is a slightly different requirement that you need to be aware of. But for purposes of what you're actually reserving for and those reserve accounts and all of that, if you're under 3 stories, it has not changed for you. So just keep that in mind. Yeah.
And you mentioned earlier to check with an engineer as to what you are if you're not sure. And I think what confuses most people, I was conversing with a few people earlier about this, like a closed garage versus what's an open air garage. Like if you're just a building with 2 levels of living, but it's an open space with nothing more than an elevator vestibule at the bottom, does that count? Check with your engineers.
Right. It's determined by the Florida Building Code, and the engineers know that much better than I do.
Let's do a couple more and then we'll get started with Kerstin.
All right. Let's see. There were a couple questions about, right, does another owner get to know when somebody's delinquent? Again, delinquency reports and any of those financials are part of the official records that an owner would get to see if they did a proper inspections request and they came in and saw those records. So we hear it all the time. We get boards that say, I don't want to give them those records because they shouldn't know that somebody's delinquent. They shouldn't know that what their owners, about their neighbor's business. It's part of the official records, guys. It's something that you'd be able to see. Just make sure everybody's current and then no one has to be embarrassed. Let's see.
My word of advice is if you're
Yeah.
a board member, don't watch the TV series Scandal about elections. Just don't watch it. It'll scare you away.
True. So again, somebody asked too, so when do we have to have these fully funded reserves? That's what we talked about. So that deadline there was if your budget was adopted on or before December 31st of 2024, after that point, we can't waive any of those CEUs reserves anymore. Can't use them for alternative purposes. The other category, your non-CEUs, you could still waive, you can still partially fund. But now we are in the world of 2025. That ship has sailed. We're not waiving anything anymore in terms of CEUs.
Yeah.
You're required to fully fund now. Now, if your board previously adopted the budget, so if you guys had your budget meeting back in November, it's possible that they did waive for this year. But now going forward, we're not going to be able to do that. So be aware. And then someone asked who files the report with the city, the engineer or the condo. Typically the engineer, I think, does it directly. They contact them, but talk to your engineer, your architect. All right. I think we hit most of the.
Yeah, many of them are just way too specific and very, very long. Thank you, Emily. Appreciate your time today.
All right. Thanks, guys. I'm going to leave you in my favorite person's hands. So, Kerstin, have fun.
Hey. No,
Awesome. Thanks, Em.
Oh, my favorite people. Sorry, my favorite people. Should have been more specific. Thank you guys for being here with me today. I'm going to go.
Thank you.
Go get a snack. So, all right.
And
Bye.
Bye-bye, Emily. And Kerstin, before you get started, just give me about 60 seconds here. Folks, remember to have the chat open. Later on, we're going to place the link. Many of you are asking about the slides. After you submit the evaluation later, this is what it looks like. You'll submit it, and I'll go over it more slowly when Kerstin is completed. But this is where you're going to get all the resources after you submit the evaluation, okay? You have Kerstin and Emily's contact information, and then the fourth bullet point is a link to open up the slides and then download them and save them. Okay, so yes, you will have that opportunity a little bit later on. Kerstin, back to you.
All right, thanks, Jeff.
You're welcome. Thank you for joining us and teaching today. We appreciate it. It's a lot of talking, we know.
It is. Emily did awesome. All right, can you see my slides?
Not just yet, but it might be a time lag. Just give it a second. Not seeing anything yet.
All right, it says I'm screen sharing.
Oh, hang on. You are. My apologies. We're good.
Yeah? Okay.
Yep.
All right, so we're going to start with topic 3. In this section, we'll talk about levying of fines, financial literacy, and transparency. And I apologize, folks, I have a little bit of a cold, so apologize for the coughing in advance. All right, let's tackle transfer fees and estoppels. All right, with transfer fees, also referred to as an application fee. This applies to communities that have the ability to approve or disapprove sales, leases, and any other types of transfers. So if you have the authority to approve or disapprove sales, leases, or any other transfer, and that authority has to be specifically set forth in the declaration, okay, then you can charge a transfer fee, also known as an application fee, in connection with that application, okay? The authority to charge that fee also has to be set forth in your governing documents, and it has to be either in your declaration, articles, or bylaws, okay? Now, if you have the ability to collect that fee, current statute provides that the fee cannot exceed $150 per applicant, other than husband and wife or parent-dependent child, which are considered one applicant. Now, as a practical tip, when we draft amendments for clients, giving them the ability to charge this fee, we don't necessarily identify the amount of the fee in the governing documents. What we do is we'll put in the amendment that the board has the ability to collect this application fee up to the maximum allowed by law, as amended from time to time. This way, if the statute ever changes, then you don't have to amend the documents every time. You just go ahead and charge the maximum allowed at that time. Now, this fee does get adjusted by the Division of Condominium. If it is ever adjusted every so many years, then the division will post it. But right now it's at $150. Now, if you allow leasing, subleasing in your condominium, just know that if the lease is renewed, then you cannot charge another fee, another application fee in connection with that lease, so long as you have the same tenant occupying the unit, okay? And basically, this fee is intended to pay for the background check that you would do on the applicant, right? Whether it's criminal or credit background check. Now, in addition to the transfer or application fee, the statute also allows associations to collect a security deposit in connection with leases. Now, in order to do that, again, you will need to have authority in your declaration or bylaws to specifically charge an owner tenant this security deposit. Now, the security deposit cannot exceed the equivalent of 1 month's rent. Okay, so whatever the prevailing rate is in your area, that's the maximum you can charge on the security deposit, and it'll be held in an escrow account that's maintained by the association. Now, please note that this security deposit is only intended to protect against damage to common elements or association property. So if a tenant is negligent and causes damage to a common element or association property, then the association will be able to recover any sums that it expends in addressing the damage. They'll be able to collect it against the security deposit. The security deposit is absolutely not intended to be any sort of prepayment for any anticipated delinquent fees or to pay any existing fines on the owner's account, or pre-suit fees, none of that, okay? Only to cover damage. All right. Estoppel certificates. Now, this will come up if a unit owner wants to sell their unit. So, and you may have experienced this. So when an owner buys into your condominium, typically the title company will send to the association or your property manager a certificate known as an estoppel certificate. And they'll want your manager or authorized representative of the association to complete the certificate and identify certain information that's requested on the certificate relative to the unit and the association, okay? And it's typically done at some point before closing, right? Because if there are any monies that are due on the unit, any delinquent amounts that the current selling owner owes the association will want to have those funds collected at closing, okay? Now, under the statute, okay, the association has 10 business days to respond to that request for estoppel information. The association has to designate on its website the person or the entity, okay, and provide the contact information or email address for receiving these estoppel certificate requests. The estoppel certificate has to be completed either by a board member or an authorized agent, right? And that could be, like I mentioned, your property manager, could even be your attorney, or any other authorized agent. The estoppel certificates have to be provided either by hand delivery, regular mail, or by email, okay? And must be signed by an officer or an authorized agent of the association. Now, I've identified here what the statute provides as the minimum information that must be reflected on that certificate. So, date of issuance, name of the owner, the property address, any parking spaces that are associated with the unit, the attorney's name and contact information, if you have an attorney representing the association, the fee for preparing the estoppel certificate, the name of the requesting party, and then importantly here, what amounts of any regular or any special assessments that are due to the association, okay? So what are owners responsible for paying in terms of assessment, and then what, if any, delinquent amounts are owed to the association. So you'll identify all those assessments on the estoppel. And then in addition to that, you will want to also identify here, number 3, what specific, number 2, what violations are outstanding on the unit. So for example, if an owner did an unauthorized alteration, let's say the owner put tiles on a balcony and they were not supposed to put tile on the balconies. That's an outstanding violation. And let's say you've sent demand letters and the owner hasn't complied. If that is an outstanding violation, you will want to notate that on the estoppel certificate, because when the new owner purchases, right, after that closing, that new owner basically assumes that violation and will now have to address the violation after closing. If you don't reflect the violation on that estoppel certificate, then essentially the association waives the ability to go after the new owner to correct the violation, right? That new owner will now have a defense that they can raise if you seek to enforce the violation against the owner. So you might want to make sure you identify every open violation. If there is a transfer fee, application amount, reflect that as well. If you have the ability to approve or disapprove the sale, right? And we talked about that being something that you'll have to have the authority expressly set forth in your declaration. If you have that language in your declaration and you have the ability to exercise a right of refusal, you'll have to identify that as well in number 4. Now, what fees can you charge in completing one of these estoppel certificates? Well, currently, the prevailing statutory rate is $299, okay? And that is if the owner is not delinquent to the association. Now, if the owner happens to be also delinquent to the association, then the association can charge an additional $179 to respond to the estoppel. If the requesting party is seeking an expedited estoppel certificate, a rush certificate, then you can charge an additional $119. Okay. Now, if the association, very important, if you failed to respond to the estoppel certificate within that 10 business day window, then you will not be able to charge that amount or any of these amounts. Now, for those owners who own multiple units, excuse me, there is also a fee schedule of the amounts that the association can charge, and we've identified them here. For most of you, this will not apply because this fee schedule starts at 25 units. But it's there if you happen to fall in that category. Now, The fees in the statute will be adjusted every 5 years to an amount that is equal to the total annual increase for that 5-year period in the Consumer Price Index, right? And the Department of Business and Professional Regulation is the one that's going to adjust this rate based on the Consumer Price Index, okay? So the rates that I just showed in the prior slide, these have been adjusted recently by the DBPR. Now, an estoppel certificate, if it's delivered by hand delivery or by email, those are effective for 30 days. So they're good for the information reflected on the certificates are good for 30 days. If the estoppel certificate is delivered by mail, then they're good for 35 days. Now, every time that you have to go back and amend or correct the estoppel certificate after it's issued, it creates a new 30 or 35-day effective period. Just be aware of that. You will not be able to charge for an amended estoppel certificate, right? So if you have to make corrections, you can't charge an additional amount. But the association can charge for a new estoppel certificate on the same sale, on the same closing, if it is issued after the previous estoppel certificate expires. So, as you may be aware, sometimes closings do fall through, or sometimes, closings are extended for, one reason or another, right? So if the prior estoppel certificate does expire, and there's a request for, an updated or reissuance of that certificate, then the association can charge for the new one. Now, the statute also provides that, sometimes the purchaser or the lien holder, which typically is the lender that is looking to give a mortgage on the unit, they might have specific questions, or they might need the association to respond to some additional questionnaire, right? Typically, you might see that from a lender that might need additional information from the association in order to be able to provide the loan. So the statute provides that if the purchaser or the lien holder requests information, well, the association can charge for providing that information, right? So you can charge as long as the fee does not exceed $150. Plus, you can charge for attorney's fees if you have to involve an attorney in responding to the question. Now, the association or the authorized agent that responded to this information is not liable for providing the information so long as you have this particular disclosure in your response. And the disclosure is here in the italics, here in the second bullet point, which is the responses herein are made in good faith and to the best of my ability as to their accuracy. So make sure that that disclosure is on the response. All right, other purchase and sale documents that you might come across. Well, there's the condo question and answer sheet. It is actually a form that you need to maintain as part of the official records that Emily discussed. And this is a form that you can actually download from the Division of Condominium website. And the Division of Condominium is the government agency that basically regulates condominiums. And they do have a website. You can Google Division of Condominium and go on their website. And this form is just a template form that they make available for associations. So it's a single page document with just several questions. Basically, what are your use restrictions? Can you lease? Are there any lease restrictions? And so you respond to those questions, and then you keep that question and answer form as part of the official records, and it is provided when a unit is being sold. And importantly, you have to update that information annually. If anything changes, right, as to any of the responses you previously provided, just update it and then keep an updated form as part of your official record. If nothing's changed, that you can keep the old one.
And Kirsten, I'll just mention everything that Kirsten just mentioned, where to find those resources. That'll appear on the confirmation page after you submit your evaluations later. So we have that link ready for you to look at after the class as well.
Awesome. And then just note that the seller's duty to provide buyer notice of all hidden defects, right? That's not something you need to worry about, but that's the onus is on the selling owner. Another thing to be aware that each prospective purchaser who does enter into a sale purchase contract is entitled at the seller's expense to a current copy of your declaration, your articles, your bylaws, your rules, and then again, the frequently asked question and answer sheet. Okay, they're also entitled to this form called the governance form, right? Which is provided by the division, and it basically summarizes the governance of condominium association. For example, what the board is allowed to do, what are the rights of owners, such as the right to attend and speak at meetings, the right to inspect association records, etc. Again, it's a form that can be downloaded from the division website. And here I've identified basically some of the information that you will find on this governance form. So I'm not going to go into detail. You can read that at your leisure after you get the slides. All right, we'll talk about the use right suspensions, voting suspensions, and fining next. All right, fining and the right to suspend use rights. And the next few slides are going to talk about fining and suspension of use rights for violations of your governing documents and association rules, not for non-payment of association funds. All right, so this is for violations of your governing documents and association rules. So specifically, the violations we're talking about is covenant violations, such as, for example, if you are a no pet building and an owner brings in a pet, that is a violation. If you prohibit the parking of trucks in condominium property and an owner brings in and parks a truck, that type of thing. So the authority to fine or suspend use rights for these types of covenant violations does not have to be specifically set forth in your governing documents. So if you've if you've ever read through your governing documents and you don't see specific authority to fine or suspend as an alternative remedy, don't fret. Essentially, the statute already gives you that specific authority. Now, the fining and the suspension process for violating the governing document really is a two-step process, right? The first part is that the board has to adopt the fine or suspension at a duly noticed board meeting. But importantly, the statute says that you cannot impose the fine or the suspension until, the violating individual has appeared in front of a committee, whatever you call the committee, suspension committee, fining committee, grievance committee, right? And that violator has been given at least 14-day notice of that committee hearing, right? So before you can impose the fine or suspension, you'll have to send the violating owner a letter letting them know of when this committee is going to meet and have a hearing. And that notice has to be sent at least 14 days before that committee hearing. The role of the committee is really not to negotiate the fine or negotiate the suspension, right? The board has already adopted it. So the committee is not negotiating that. The committee's sole function is really to either ratify the decision of the board or reject it. It really is only a yes or no vote. You're not there to reduce the fine if you feel, compelled to do so. You're there to simply vote yes or no on the suspension or the fine. Now, the impartial committee, however you decide to call it, has to consist of at least 3 members. who are not officers, they're not directors or employees of the association, or the spouse, parent, child, sibling of an officer, director, or that employee. So it has to be completely impartial unit owner. For some associations, that actually is a problem. You are potentially, a small condominium, and you might have issues finding that impartial committee member. So for those associations that are struggling to find such individual, well, finding and suspension of use rights might not be a viable remedy for you. Okay. For those that can find those impartial committee members, well, this could be an option of enforcement, right? It's an alternative. It's not the sole mechanism by which to enforce a violation, just another option. Now, the statute does say that the fine cannot exceed $100 per violation, and it may be levied on the basis of each day of continuing violation, with a single notice and opportunity for a hearing, but cannot exceed 1,000 in the aggregate. So what that means is, let's take the violation of the individual who brought in a pet to a no pet building, right? For every day that, after you send that notice of violation, for every day that that pet remains in the unit, right, you can tack on that $100, up to $100. Up to a maximum of 1,000 for that pet violation. Okay, that's how that works. Now, a fine cannot become a lien in the condominium setting, right? HOAs have a little bit more authority to lien if they have certain authority in the documents, but for condominiums, the current state of the law is that you cannot recover a fine as a lien against the unit. Okay, what that means is, after you've gone through your process to approve the fine and the committee has confirmed the fine, okay, the fine will be due within 5 days after the date of the committee meeting. Okay, but if the owner does not pay the fine, that essentially this fine will just sit on the account ledger. You'll reflect it on the account ledger, and it'll just sit there. Hopefully, when the unit sells, you'll reflect the fine on that estoppel certificate that we discussed moments ago, and then hopefully you'll get paid at closing. Okay. Yes, there's an option to potentially, recover it through small claims court, but practically speaking, realistically, you're not going to spend $500 to file a lawsuit in small claims court to recover 1,000, right? And so these fines then just simply get reflected on the account ledger, and you move on. The right of suspension. And by the way, after you've gone through the process of fining, right, if the owner still has not addressed the violation, then you might have to consider other options for enforcement, and that could be sending a demand letter to the owner, right, to either cease or desist the conduct, or to, take action to address the violation. And then if the owner still doesn't comply, then you might have your attorney send a violation letter, and then if the owner still doesn't comply, well, there's the pre-suit mediation arbitration that you have to go through before you file a lawsuit in court to force the owner to comply. Excuse me. All right. In addition to suspending use rights for violations of the governing documents, and again, it's the same process as fining, right? The board needs to adopt the suspension, and then the committee has to confirm the suspension for violations of the governing documents. In addition to that, the association has the ability to suspend use rights if an owner is delinquent on monetary obligations due to the association, which have been delinquent for more than 90 days, right? So the monetary obligation could be, whether it's regular assessments, special assessments, certainly any attorney's fees or any interest or late fees if you have the ability to collect late fees on delinquent assessments, right? So if the owner's delinquent for more than 90 days, well, the association can also suspend use rights. Now, to suspend use rights for a delinquency, you don't have to go through that two-step process, right? It's something that only the board can do at a duly noticed board meeting, right? So you basically post notice of the meeting at which you're going to suspend use rights, and then take action at that meeting. Now, when we talk about suspension of use rights, whether for violations of the governing documents or because the owner is delinquent on his or her account, we're talking about suspension primarily of common facilities, right? So, your clubhouse, maybe pool area, gym, library, and any other facilities, recreation areas that you have, and to which you have the ability to control access, right? So if you have the ability to deactivate a fob, then this could be a viable enforcement mechanism to compel payment, or to compel compliance with a covenant violation. If not, if you don't have the ability to control access to these facilities, well, again, this might not be an option for you, right? Now, the statute does say the suspension cannot apply to limited common elements intended to be used only by that unit. So, for example, if balconies are considered a limited common element to the unit, well, you can't suspend the ability of an owner to use their balcony. You also cannot suspend an owner's right to use common elements needed to access the unit. Utility services provided to the unit, parking spaces, or elevators. So you can't prevent an owner from parking in their parking spaces or from getting on the elevator to get to the unit. You cannot prevent an owner from getting access to the community. So if you have a gated community, the owner has to be able to go through the gate. Now, you can make it more difficult for the owner to get in to the community if it's gated, if there's an option to go through a guard. Okay, but if there is no alternative option to get in other than through, a single gate with a fob, then you cannot deactivate the fob. Okay, the owner has to be able to go into the unit. If an owner is delinquent for more than 90 days, you also have the ability to suspend the owner's voting rights. And for many, this could be a useful tool, especially if you're looking to get owners to approve certain action. And so the ability to suspend voting rights might be a useful tool. And the reason is because once you suspend voting rights, well, the statute says that those units that have been suspended, properly suspended, well, they won't be counted towards the quorum requirement that you need to meet, and they won't be counted towards the voting percentage you need to achieve. So this is something that can be done also only by the board at a duly noticed board meeting. Right? You don't need to have a committee hearing in order to suspend voting rights. The owner needs to be, however, delinquent on any monetary obligation to the association for more than 90 days. And the delinquency has to be greater than $1,000. That's only for suspending voting rights. So more than 90 days delinquent, and the delinquency has to be more than $1,000. And proof of the obligation must also be provided to the owner at least 30 days before you suspend voting rights. Now, there is case law that came out in 2020 that suggests that if you If you do not have Kaufman language in your declaration, and Kaufman language are those magical words as amended from time to time, then essentially you need to specifically have your declaration provide you with the authority to suspend voting rights. So while this authority is already in the statute, this specific case seems to indicate that to suspend voting rights, unless you have Kaufman, you need to have that authority specifically in your declaration. Okay, so get with legal counsel if this is something that's not already in your declaration and you want to put it in your declaration by amendment. So again, if you go through the process of suspending voting rights correctly, then just note that those units whose voting rights you suspended, again, would not be counted towards quorum, and then would not be counted towards the percentage that you would need, the approval percentage you need to obtain in a specific action. So, for example, if you're looking to amend your declaration, and you know, let's say you want to prohibit leasing, and this is something that's very controversial in your community. Well, if let's say you've suspended the voting rights of 10 owners, and you have a condominium with 100 units, well, again, quorum, let's say quorum in your community is a majority of all the owners. Well, with the suspension in effect, you would need to establish quorum a majority of the 90 owners, not a majority of the 100 owners. And let's say you need the approval of a majority of all the owners to get those amendments passed. Well, again, it will have to be a majority of the 90, not a majority of the 100 owners to get the action approved. All right, let's switch gears and talk about budgets, reserves, and financial reporting requirements. All right, so the board has an obligation to prepare an annual budget. That means every year you have to prepare an annual budget of your estimated revenues, operating costs, and reserves for the upcoming fiscal year. The budget also has to reflect the beginning and ending periods of your fiscal year, and then the total assessments for each unit type. You will be surprised. There are many accountants that for one reason or another, assuming the association is getting guidance from the accountant, that don't necessarily reflect even the basic elements of what an association budget needs to have. So make sure that you get an accountant that is familiar and has experience in dealing with association budgets. I have dealt with division complaints filed by owners who have complained that the association doesn't have a proper budget. Okay, and the division of condominium takes these violations very seriously, which could subject the association to monetary penalties, even if it is your first violation, even if this is a new board coming in and you've never done this before, and this is the first year you're in and you were not supposedly aware that this is how your budget needs to be done. It doesn't matter. You could subject the association to monetary penalties if a violation is found. So get with an experienced accountant or an experienced, a management company to assist you in preparing the budget. Now, at a minimum, your budget is going to reflect, the following items. You'll probably have administration expenses, management fees if you have a management company. Certainly, amounts that you will expend in a year in addressing maintenance issues of the common elements, insurance expenses, professional expenses. You might have an attorney, and if you don't, you should absolutely consider having legal counsel. Remember, folks, you are operating a corporation. It's not just an association. An association is a not-for-profit corporation that's governed under Chapter 617 of the Florida statute and 718. So you're in essence running an entity, right? And you're not expected to know everything about running a corporation, much less a condominium association, right? The law has become increasingly more complicated over the years. I mean, attorneys fight over their interpretation. Imagine, inexperienced board members. So absolutely, you should have legal counsel representing the association. You should have an accountant, okay? And you might need an engineer, right? Whether you're a building that's had to deal with the CEUs recently or a milestone inspection, or if you have other issues, you might need an engineer. So these are all professional expenses that you should be anticipating. And you might have other expenses, right? And then certainly you'll have a reserve section of the budget, right? And then there's fees that have to be paid to the division annually. So you'll include those as well. Now, the statute addresses the budget adoption process. You might have in your bylaws a more restrictive process. So you go with the more restrictive process if it's a little different from what the statute provides. But at a minimum, what the statute provides is that you have to provide owners with notice of the meeting at which you're going to adopt the budget, along with a copy of your proposed annual budget at least 14 days prior to your meeting, right? And you can either, you will have to either mail it or hand deliver it, or you can email the notice with a budget to those owners who have consented to receiving notices electronically. And we'll talk about notice requirements later on, okay? But it's at least a 14-day notice requirement. Now, if you have in your bylaws, a 30-day notice requirement for budget meetings, you go with that. Proof of notice has to be provided by affidavit, and it has to be signed by the individual that's providing the notice. And an important note here, the last bullet, if you make a change to the budget during a properly noticed budget meeting, you do not need to rescind or renotice the budget meeting. Remember, a budget is an estimate, right? So if you've already provided owners with a budget, proposed budget, and at the meeting, while you're talking about numbers, you've received new information, right? Which means you have to modify the budget slightly. It's okay. You can adopt it at that meeting. You don't have to, resend or renotice that meeting. Now, as of July 1st of 2021, when this change took effect in the statute, the board is now required to adopt the annual budget at least 14 days prior to the start of the association's fiscal year. When is your fiscal year? Well, that will depend on what your bylaws provide. It could be calendar year, right? January 1st through December 31st, but it could be anything in between. So look at your bylaws to see when is your fiscal year, and the budget now has to be adopted at least 14 days prior to that. Now, the statute also says that if the board fails to timely adopt the budget a second time, it's deemed a minor violation. I don't know why they put a second time and not a first time. I don't know, who knows what the legislature was thinking, but that's what's in the statute now. Obviously, if you don't properly adopt the budget, any owner can file a complaint with the division. All right, let's talk about reserves. Now, Emily talked about the structural integrity reserves, right? What we're talking about now are the traditional reserves. Okay, this applies to all condominiums, those that are over 3 stories and those that are under 3 stories, because these reserve requirements, which have been in the statute for decades, has not gone away. The only thing that was added to the statute were the CEUs requirements for those buildings that are at least 3 stories or higher. Okay, but these reserve requirements still apply to everybody. So we've provided definitions here for what is a capital expenditure and what is a deferred maintenance. And examples would include your roof replacement, building painting, pavement resurfacing, balcony restoration, seawall replacement, air conditioning replacement, right? And you could have more. So what the statute says is that a budget must include reserve accounts for capital expenditures and deferred maintenance at a minimum for your roof replacement, your building painting, pavement resurfacing, and then any other item that has deferred maintenance expense or replacement cost that exceeds $10,000. It is a must. You must have a budget that reflects a reserve schedule, including these items at a minimum. You might have more, right? Somebody talked about, I think, elevators. Every so often, elevators have to get modernized, right? And that could be $300,000 plus, depending on how many elevators you have, right? That is something that should be reserved for. It's not in the CEUs, but it would need to be in your statutory reserve schedule. How are you going to compute reserves? Well, it's going to be based on a formula based on estimated remaining useful life and then estimated replacement cost of that reserve item. So if you haven't done a reserve study, recently, forget the CEUs again, right? We're not talking about CEUs. We're just talking about regular statutory reserves. If you haven't done a reserve study, then absolutely you should get one, right? So the reserve specialist will come onto your property, will evaluate your common elements, and then provide you with a schedule. What is the remaining useful life of these assets? For example, your roof, how much time is still left on your roof? And then how much is it going to cost to replace that roof at the end of that useful life, right? And then the schedule is going to identify how much you have to fund for each year that remains so that you have enough funds to replace it at the end of that useful life, right? So we've put here basically what your reserve schedule has to include. And again, work with an accountant that is experienced in, condominium associations. They should know this. Your reserve schedule will need to identify the total estimated useful life of the asset, the remaining useful life, the estimated replacement cost, and then the estimated fund balance as of the beginning of the period which the budget is in effect. We'll talk about pooling reserves in a minute, but this is the schedule you need to have whether or not you're pooling reserves. Now, I mentioned that your annual budget has to include a reserve schedule with fully funded reserves. What that means is, let's take an example of your roof replacement, right? And let's say you have 10 years left on that roof, and it's going to cost you $100,000 to replace that roof at the end of that useful life, right? So now you know that for the next 10 years, you have to fund your reserves by collecting at least $10,000 each year for the next 10 years. Is that correct? Yes. Okay, so that you have the money you need to replace it at the end of the 10 years. Now, the statute, however, does give the board the ability to present to the owners the option to waive those reserves as well as to partially fund reserves. This does not apply for CEUs, right? Emily told you that, for CEUs reserves, you cannot waive them. Okay? You will not be able to partially fund them, after December 31st of 2024. That window has closed if you didn't properly take action to have those reserves waived, okay? But for these non-CEUs reserves, you still have the option as a board, if you want to, present to the owners the option to waive or partially fund. it is completely within the discretion of the board whether you even want to give owners the option to vote on waiving or partially funding. So if you as a board feel that you know what, no, we should be fully funding these reserves, then the budget needs to reflect fully funded reserves. Okay. If you want to give the owners the option on any given year to fully waive reserves or partially fund reserves, then that is a vote of the owners. So you'll have to have a special membership meeting to that effect. You'll have to mail out proxies, and the owners will need to vote on that. Now, the vote that you need to get to waive, for the owners to waive or partially fund reserves, is a majority of the voting interest. It used to be a majority of quorum, but obviously with everything that's happened, that vote has been increased. So now it's a majority of the voting interest. If you do get an owner vote, if enough owners, the requisite number, do vote to waive or partially fund reserves, then then those waived or partial fund reserves are applicable only for the budget year in which the vote was taken. So that means every year, if you want owners to waive reserves next year or reduce reserves, you'll need to get a new vote, right? It's not, if they took the vote in 2025, it's not a vote for eternity. No, in 2026, if you want to give the owners the same option, you'll have to present the issue again, and so forth and so on, every year. As a practical tip, okay, remember, owners have to vote to waive or reduce reserves, right? But remember, we talked about that the budget still has to reflect fully funded reserves unless you get that owner vote. So the sequence of events, how it should play out is you should have your special membership meeting. You could have your board meeting and your special membership meeting on the same day, but you should have your special membership meeting to waive or partially reduce reserves, whichever option you're giving the owners. You should have that membership meeting first. That way, at that meeting, you count your limited proxies, you count the vote, right? And then when you adjourn that meeting, you should have your board meeting to adopt the budget. And then depending on whether or not you obtain the vote, you'll know what budget you're going to approve, whether it's a budget with fully funded reserves, if you didn't get the necessary member vote on the waiver or partial funding, or you will be approving the budget with either waived or partial reserves if you actually got that vote at the membership meeting. Many boards get this process or sequence of events sort of backwards, and it could subject you to a potential legal challenge. So make sure you have the member vote first, and once you know whether or not you got the owner vote on the waiving or partial funding, then you will know what type of budget you're going to be adopting. Now remember that reserve funds can only be used for reserve items, right? So if you have reserves for roof replacement, you cannot use those funds to paint your building. Or if there's an emergency, you cannot use those funds to, fix elevators, for example, okay? The only way that you can use reserve funds for anything other than the reserves for which they were allocated is by getting an owner vote. And the vote that you need is a majority vote of the voting interest. Okay? Now, reserve accounts, you can have reserve accounts, a straight line accounting method. In other words, every reserve item would be its separate reserve account, or there is the option to pool reserves. Pooling reserve means basically you put the funds that you've allocated for different reserve items in one big pool, right? If you do that, then obviously you have a little bit more flexibility on how you can use these reserve funds, right? So those reserve funds that are in that pool, now you can use them for any item that's in the pool. So if you've pooled reserves for your roof replacement, for your elevator modernization, for your painting, And let's say you absolutely need to replace the roof next year, but you don't have enough funds yet in the roof category, and you want to borrow a little bit of money that has been allocated for elevator modernization because you don't have to modernize your elevators just yet. You have the flexibility to use funds allocated for elevator modernization to pay for the cost of the roof replacement if these are all the items in the pool. You don't need a membership vote. Now, if you have been maintaining reserves in a straight line accounting method and you want to pool them, that change will require a membership vote, okay, which is a majority of the voting interest. If that's something that interests you, then speak with your legal counsel and then certainly with your accountant on how to do that. Now, the statute does say that if you are going to give owners the option to waive or partially fund reserves, then you have to have this disclosure that we've provided here in all caps on the ballot as well as on the limited proxy. Basically letting owners know that if you are waiving or partially funding reserves, right, or you're using reserves for alternate purposes, well, guess what? You could subject yourself to a special assessment, so just beware. All right. All right, financial reporting. So in addition to maintaining and adopting a budget every year, you have to prepare, the association has to prepare a financial report of the preceding year's financial activities. And you got to do this every year. And it has to be done within 90 days after the end of your fiscal year or annually on the date provided in the bylaws, right? So remember, again, go to the bylaws to check when your fiscal year is. And it has to be, the financial report has to be prepared within 90 days after the end of the fiscal year. Or your bylaws might have a specific date by which you have to have that report prepared, in which case you go with the date that's in the bylaws. Now, within 21 days after the financial report is completed, but no later than 120 days after the end of the fiscal year, the association has to mail or hand deliver to each owner a copy of that financial report, and notice that a copy will be mailed or hand delivered to a unit owner without charge within 5 business days upon receipt of a written request. The association also has to provide an annual report to the department containing the names of all the financial institutions with which it maintains accounts. Okay, and then a copy of that report may be obtained from the department upon written request of any association member. Now, the level of financial reporting or the type of financial report that you're going to have to prepare is going to depend on the annual revenue of the association. Unless, of course, in your bylaws, you specifically have the requirement to do a financial audit. So if your bylaws require you to do a financial audit every year, regardless of your annual revenue, then you have to do that audit, unless you amend your bylaws, right? Otherwise, your financial report is going to be based on your annual revenue. So what the statute says, for example, if your total annual revenue is between $150,000 but less than $300,000, then all you have to do is prepare compiled financial statements, right? So per the statute, if your total annual revenue is $500,000 or more, then you have to do a financial audit. Now, a new change in the statute that took effect July 1st is that, members, the membership can vote to reduce the level of financial reporting, right? So for example, if by statute you're required to do an audit, not a requirement in your bylaws, but if by statute you have to do an audit, you can get owners to reduce the level of financial reporting to maybe, reviewed financial statement if you get the necessary owner vote. So the change that went into effect July 1st is that members can vote for a reduced level of financial reporting, but you can't do it for consecutive fiscal years. So you no longer will be able to do this consecutive fiscal years. All right. And we're on topic 4. So here we're going to cover notice meeting requirements, insurance requirements, and then conflicts of interest. All right, membership meetings. So first thing is, there are 2 types of membership meetings. And a membership meeting is a meeting at which owners vote. We'll talk about board meetings in a moment, but board meetings are meetings where the board votes. Now, typically, the business affairs of the association are conducted by the board, but there are certain issues or matters upon which owners get to vote. For example, if you're amending your governing documents, that's an issue that owners vote. If you are, for example, if you want to waive reserves, again, that's an issue that owners vote. So if it involves an issue that owners need to vote on, then you're going to have a membership meeting. Now, there are 2 kinds of membership meetings. There's the annual members meeting, and then there's a special membership meeting. The annual meeting, for many associations, it's the one and only meeting you will have every year. You have to have an annual meeting. If nothing else, that's the one meeting you're going to have every year. And it is at this annual meeting that you're going to have your election, which Emily discussed. Okay. Now, the annual meeting has to be held typically on that date, time, and location that's set forth in your bylaws. If your bylaws are silent as to the location, the meeting has to be held within 45 miles of the condominium property. Membership meetings in general also have to be held at a location that is accessible to physically handicapped persons if requested by a physically handicapped person. Now, the bylaws have to provide the method of calling meetings for the unit owners, including the annual meeting. So you have to go to the bylaws to check what the notice requirements are. With the annual meeting, as Emily mentioned, the statute does require that first notice and that second notice to be sent out, right? So some of the older condominiums might have in their bylaws, requirements to send out notice of the annual meeting, at least 14 days in advance. Obviously, that is in conflict with what the statute provides for elections, right? So you go with the statute. And like I mentioned, your election is going to be conducted at that annual meeting. Other than the annual meeting, any other meeting that you're going to have in any given year at which owners vote will be called a special membership meeting. Okay. Now, when are they held? Well, typically when called by the board. So if the board needs owners to vote on something, they will call the meeting by properly noticing it. But also owners have the ability to force the board to have an annual, to force the board to conduct a special membership meeting if requested by at least 10% of the unit owners, unless, of course, your bylaws provide for a different percentage. As with any notice, your notice of a membership meeting is going to identify the date, the time, the location of the meeting, and it's going to identify agenda items, right? Everything that you're going to be discussing at that meeting, everything that owners are going to be voting on. Unless your documents provide otherwise, notice of a membership meeting, and in this case would be special membership meeting, because remember the annual meeting for elections, they have the first and second day and second notice requirements, but for a special membership meeting, you'll need to provide notice to the owners at least 14 days prior, as well as post a copy of that notice on Condominium Association property at least 14 days prior. Notice has to be mailed to each owner at the address that was last furnished to the association. And notice can be, again, can be either mailed, can be also hand delivered, or can be electronically transmitted, and we'll talk about that in a minute. Proof of notice, the individual that's providing notice of the membership meeting has to sign an affidavit attesting that notice was properly sent. Typically that is a property manager can sign the affidavit, but if you are self-managed, certainly your secretary, that would be a function of the secretary, and the secretary can sign the affidavit. Now, in addition to mailing, hand delivering, and posting the notice, in addition to that, the association may adopt a rule, right? Adopting procedures for conspicuously posting and broadcasting the notice and the agenda of the meeting on a closed circuit cable television system serving the association. So for those communities that have a bulk service contract, right, and you have a closed cable television system, this could be an option to broadcast the notice. Now, in addition to mailing and hand delivering, you have the option of providing official notices of membership meeting and as well as board meetings to owners electronically, but only to those owners who have consented in writing to receiving official notices electronically, right? The written consent has to be signed by the record owner or the person holding the power of attorney. And that consent or revocation can be delivered, by mail and certainly electronically via email. Okay. So for those owners who have not consented to receiving notices by email, you'll have to provide notices in any of the other ways. Do note that electronic notices cannot be used for recalling a director or on the vote to forgo retrofitting of the condominium with a fire sprinkler system. Those are the only two issues that you cannot email notice to the membership. Notices of a meeting is effective when it is sent by the association, regardless of when the notice is actually received. Now, if an owner consents to receiving notices electronically, you are required to then maintain the email addresses and the fax numbers for those owners. And just be aware that for those that did consent to receiving notices electronically, those email addresses will now become accessible to unit owners. That means that if an owner makes a request to inspect the official records, they can see the roster or any spreadsheet that might have the email addresses of these owners. So if you don't want to have your email address accessible to other owners, then you'll need to revoke your ability to obtain notices electronically. All right, Emily talked about website requirements for those associations that are that have condominiums with 150 or more units, right? You still have the obligation to post meeting notices and agenda on your website at least 14 days prior to the meeting. And then, depending on the action, if there's any document that is associated with the membership vote, for example, if you're having owners voting on amendments, then that document also has to be posted on the website at least 7 days before the meeting. For those associations with less than 150 units, right now, that's not, you don't have a requirement to maintain that website. That's going to change, as Emily talked about, come January 1st of 2026. But for right now, if you have less than 150 units, you can, adopt a procedure for posting meeting notices and agendas on the website if you have created one. All right, quorum requirements, unless a lower number is provided in your bylaws, quorum for membership meetings will be a majority of the total voting interest. So obviously check your bylaws to see what your quorum requirement is. I've never seen it more than a majority, but I've definitely seen lower quorum requirements, especially if you've amended that requirement in the past. Decisions of the membership, well, again, unless otherwise provided in the statute or in your association governing documents, decisions to be made by the members have to be approved by at least a majority of the voting interest represented at a meeting at which a quorum is present. So, for example, if you're looking to amend the declaration, and the declaration requires the approval of 2/3 of all the owners, well, then you're going to have to go with the 2/3 vote requirement, not this one that's on the slide. Same thing with the statute. The statute, for example, we've talked about for waiving reserves requires a vote of a majority of the voting interest, okay? So you have to get that vote, the majority of the voting interest, not a majority of quorum. And I'm not sure if Emily touched on this, but what this means, majority of voting interest represented at a meeting at which a quorum is present. What that means is, let's take your condominium of the 100 units, right? So the first agenda item at any membership meeting is to establish quorum. And quorum basically means the least amount of members that must be present at the meeting in order for the meeting to continue and to conduct the business that's set on the agenda, right? So let's assume that for this association, quorum is a majority of the voting interest. So it's 50% plus 1 of the 100. So assuming you have achieved quorum, you can continue with the agenda of the meeting. But let's say for this particular issue, let's say, amending the governing documents, you need a vote of, the majority of quorum. What that means is, if the minimum number of owners present at this meeting is 50% plus 1, then majority of quorum means that you need to get the affirmative vote of majority of the 50% plus 1 for the particular issue to pass. Not a majority of all, but a majority of the 50% plus 1. Okay, so that's the vote that you would need to get in that instance. Now, we talked about membership meetings, right? And getting owners vote at a membership meeting. Well, in lieu of a membership meeting, you have the option to get the vote by the written consent process. The only way you would be able to do that is if your documents allow you to get a vote by this process. And what this process is essentially it kind of works as a proxy. So instead of sending out a notice to the owners along with a limited proxy in a particular issue, all you would do is you will send out a memorandum or basically a cover letter indicating what you want owners to vote on. So on the particular, if it's an amendment to, let's say, your declaration, so you'll say, you know, enclosed is an amendment to the declaration that we want owners to vote. And if you are in agreement with this amendment, please indicate your consent at the bottom of the form. And then the owner who consents to the amendment basically signs the bottom of the form and then returns the written consent form to the association. Only if you're in favor of the particular action that's reflected on the written consent will you need to return it. So owners who are not in favor of the action don't have to return the form. And once you, you'll still need to get the consent form from enough owners to get the vote that you need. But note that consent form, you'll have 90 days from the date of the first executed consent form within which to get the necessary consent that you need. So you have 90 days to work with, very similar to a limited proxy, which we'll talk about in a moment. Again, the flexibility of obtaining the vote by the written consent process is that you don't need to get a membership meeting, right? So especially if you're in a condominium where there's a lot of absent owners, seasonal owners, this might be something that you might want to consider. And if you don't currently have this ability to obtain action by written consent, then you might want to consider amending your documents to give you that authority. This was definitely a very helpful tool during COVID for those associations that that did have this ability. Member participation. Owners have the right to speak at members' meetings with regard to any agenda item that's listed. But the statute also gives the ability to the board association to adopt rules governing the frequency, the duration, and manner of member statements. So if you want to, for example, place a time limit of how many minutes each member may talk on a designated agenda item, you know, certainly a reasonable number would be acceptable. Note that members also have the ability to record and videotape a meeting, all right, subject to the rules adopted by the division. And we've noted here some of the rules. For example, only audio or video equipment that does not produce distracting sound or light emissions can be used. If adopted in advance as a written rule, audio or video equipment must be assembled and placed in position in advance of the meeting. Also, if adopted in advance as a written rule, anyone videotaping or recording cannot be permitted to move about the meeting room in order to facilitate recording. So again, you might want to speak with legal counsel to adopt some reasonable rules regarding videotape recording. All right, proxies. There are two types of proxies that you will encounter in the association setting. There's a general proxy and then there's a limited proxy. Proxies are used when an owner is unable to attend a membership meeting. A proxy will typically be mailed out with a notice of the meeting. And it serves two purposes. One primary purpose is that the proxy can be counted towards quorum requirement. So if the owner cannot physically attend the meeting, remember you still need to meet quorum. So they can sign, the owner can sign the proxy and then mail the proxy or hand deliver it, or email it in advance of the meeting, and that proxy can then be counted towards the quorum requirement. And then if you're having the owners vote on a particular issue for which you would need a limited proxy, then the limited proxy will actually designate how the owner voted. So general proxy, if you don't really have anything specific that you want owners to vote on, But you have other items, but you have agenda items, for example, in an annual meeting. If in addition to the election, you want to have other, reports, you want to have committee members or board members provide reports or state of the affair of the association, you need to establish quorum for that part of the meeting, right? So a general proxy would assist in establishing quorum. Limited proxy is typically used when you need owners to vote on something specific. And in fact, the statute tells you that a limited proxy is required for certain types of votes. For example, to vote on waiving or reducing reserves, waiving financial reporting requirements, certainly to amend your governing documents. The distinction with a limited proxy is that the limited proxy would actually have the question that you would see on the ballot. Right? And then the unit owner that's unable to attend the meeting can designate whoever they want as the proxy holder, but they also get to actually designate on the limited proxy how they're voting on the particular action. They're either checking off, yes, I agree, or no, I disagree on the particular issue. Then they sign the proxy, and then they can either mail it to the manager or a board member, or, hand deliver the limited proxy in advance of the meeting if they can't attend on the date, or give it to the neighbor, and then the neighbor can bring it to the meeting. Couple of things to point out with proxies. A proxy, whether it's limited or general, cannot be used to vote in an election or to forego retrofitting. Emily talked about elections and how important it is that now, especially with the new changes in the law, you don't, forge or sign anyone else's ballot, right? So again, you cannot vote by proxy in an election. That's not gonna fly. A proxy is effective only for the specific meeting for which it's given, but it is also effective for 90 days. So, let's say February 1st, you have a meeting for owners to approve an amendment. And let's say you don't get the votes that you need. Well, that proxy is good for 90 days. So there is an option to recess and reconvene that meeting for as many times as it's necessary for you to try to get the necessary votes up to that 90th day. Right? So speak with legal counsel about what that process is. But again, proxies are good for up to 90 days. And proxies are revocable at any time at the pleasure of the member executing. All right, let's move on to board of directors, notice meeting requirements. So officers and directors have a fiduciary responsibility to unit owners and must act reasonably. But they're not experts in all things condominium. So you're going to have to rely in your experts, your attorneys, your accountants, your engineers, your contractors. It's okay to be not right all the time, as long as you exercise your best business judgment, and obviously all decisions are made in the best interest of the community. Directors cannot be compensated unless authorized in your governing documents, and we'll talk about also conflict of interest momentarily. Now, unless otherwise provided in your governing documents, the corporate powers of your association are exercised by the board. So what that means is that no single board member, should really be making unilateral decisions unless, of course, you have resolutions, minutes that reflect where certain power or certain authority has been delegated to a particular board member. Otherwise, the board needs to make decisions collectively. Board is generally responsible for the maintenance of association property, right? And like I mentioned earlier, board generally is the one that takes action and votes on general association matters, right? Maintenance, repairs, contracts, unless there's something specific in the statute or in the governing documents requiring owners to vote. Other than that, it's going to be a board decision. An officer, director, or manager may not solicit, offer to accept, or accept a kickback. And a kickback is a term that has been defined in the statute, and essentially it means anything or service of value for which consideration has not been provided for an officer, director's, or manager's own benefit or that of their immediate family from any person that's providing or proposing to provide goods or services to the association. So any officer, director, or manager who knowingly solicits, offers to accept, or accepts a kickback commits a felony in the 3rd degree and is subject to civil penalties and must be removed from office. Now, there is no prohibition against an officer, director, or manager from accepting services or items received in connection to trade fairs or education programs. So, for example, there's lots of trade shows and expos throughout the state of Florida. I know there's a few coming up in the month of February for West Coast of Florida here in the Tampa area, which I'll be attending. If you've ever attended these, basically a lot of vendors are there present, vendors that deal with associations or in the business and assisting associations. And you go from table to table and they all have goodies and there's lunch provided. It's okay to accept those knickknacks or items at trade shows. You're not in violation of Florida statute. Now, new change in the law, an association, its officers, directors, employees, and agents may no longer use a debit card issued in the name of the association or billed directly to the association. A person who uses a debit card issued in the name of the association for any expense that is not a lawful obligation of the association commits theft and must be removed from office. That was a provision that hasn't been in the statute for some time. Now, a director, officer, or officer who is charged by information or indictment with any of the following crimes has to be removed from office. That is forgery of a ballot envelope or voting certificate, theft or embezzlement involving association funds, destruction of or refusal to allow inspection or copying of any official record within the time periods required by law in furtherance of any crime. Certainly obstruction of justice, and then any other criminal violation under the Condominium Act. A board must fill the vacancy until the end of the suspension period or the end of the director's term, whichever occurs first. And then if the charges of this particular director or officer are resolved without a finding of guilt, then the director or officer has to be reinstated for the remainder of his or her term if there's any time remaining. An officer or director who has such charges pending may not be appointed or elected to a position as a director or officer of any association. How to get off the board? A few ways. You can certainly resign in writing. There's the recall process. Remember, with recall, we're not going to talk about it in this in this certification class, but essentially the recall process is one where the membership votes to remove any particular director. If you are delinquent in the payment of any monetary obligation due to the association for more than 90 days, then you deem to have abandoned the seat, creating a vacancy. So if you're delinquent for at least 90 days, that's a sure way to get yourself off the board. certainly criminal charges involving theft or embezzlement, for a knowing or willing violation of the Condominium Act. The division can order the removal, and then failure to satisfy the certification requirement, in which case you will be suspended until you comply with your certification requirements. Now, new changes in the statute, which took effect July 1st. In a residential condominium of more than 10 units, boards now must meet at least once each quarter. Okay, so not, having that one board meeting, not good enough. You have to meet now at least once every quarter. And then at least 4 times each year, the meeting agenda has to include an opportunity for members to ask questions. Now, there is no statutory requirement for the board to answer questions, but certainly owners have to have the opportunity to ask questions. So as a practical tip, just make sure that at least 4 times each year, your notice of a board meeting includes a specific agenda item for owner questions. Now, the law does allow at times for the board to take action outside the context of a properly noticed board meeting, okay? And if you do that, and that could be, in events of, an emergency, you will still have to ratify the previous action at the next duly noticed board meeting. The statute also allows board members to use email as means of communication. So directors can email one another and have these discussions. You just cannot use email to cast a vote. So please don't get in the habit of just emailing each other and then, later on sort of rubber stamping your decision that you've already sort of made via email, right? Make sure that you have these duly noticed board meetings to conduct association business, have discussions before you vote on any particular item. Now, most board meetings, you would only need to post notice of the board meeting at least 48 hours prior to the meeting. So you'll post the notice on condominium or association property where you typically post notices, right? And again, you'll identify the date, time, location, and then agenda items. There are at least 2 types of meeting under the statute at which you have to provide 14-day notice. Now, that said, if your bylaws require a longer notice, or if your bylaws require for other types of meetings to be sent out 14 days in advance, then obviously you go with the more restrictive bylaw requirement. But the statute does say that notice of a board meeting at which you're going to adopt a non-emergency special assessment, or if the board is considering an amendment to rules regarding unit use, not a rule about, use of your common facilities, your pool, your clubhouse, but a rule regarding unit use, then for those types of meetings, you have to either mail, hand deliver, or email notice of the meeting at least 14 days prior. Okay, and then you also have to have an affidavit attested by the individual that provided notice, indicating that the notice was properly provided. The board, by rule, has to designate a specific location and condominium property at which all notices must be posted. If there is no condominium property, then notices have to be mailed, delivered, or electronically transmitted to each owner at least 14 days prior to the meeting. And then for those that do have a closed circuit cable television system, well, you also have an option to adopt a procedure for posting these notices and agendas on that closed circuit cable system. Also, for those associations that are subject to the current website requirement, you also have to post copies of your meeting notices on that website. at least, 48 or 14 days prior to the meeting. If you are not currently subject to the posting requirement, but you have a website, that is an option for you as well to post your notices. Excuse me. Now, board meeting notices, they have to specifically identify the agenda items, as I've mentioned. Now, sometimes you're at a board meeting and you might have an emergency issue that was not initially reflected on the agenda of the notice, but you need to take up an item on an emergency basis. That happens. If you do, as I mentioned a few slides ago, that's an action that you would need to ratify. If the board, for example, wants to raise another issue at that meeting that was not specifically on the agenda, might not necessarily be an emergency, but wants to raise another issue, when, as long as a majority plus one of the board of directors agree to take that issue up, you can. But again, you will need to ratify that issue at the next meeting. In addition to the board, calling meetings, the owners have the ability to force the board to also call board meetings. So if 20% of the voting interest petition the board to address a particular item of business, then the board, within 60 days after receipt of the petition, must place the item on the agenda at its next regular board meeting or special meeting. Okay. Another change that went into effect July 1st is that if the agenda includes an item, approval of a contract for goods or services, then the statute now requires that a copy of that contract has to be provided with the notice. Okay. So if you are looking to approve a contract, the notice has to provide a copy of that contract, and owners are entitled to access that that contract by making a records inspection request as well. If you're going to adopt a special assessment, right, the statute also provides specific instructions on what that notice have to include. So notice of the meeting at which you're going to adopt a special assessment has to specifically state that a special assessment will be considered. It has to provide the estimated cost, right, or the estimated amount of the special assessment, and then it has to provide the description or the purpose of that assessment. It is so important that your notice of special assessment is done in accordance with the statute, because what's going to happen is, if after you adopt a special assessment and the owner doesn't pay, and you then refer the delinquent account to your association counsel to pursue collections, lien and foreclosure, if that notice was not properly done, for example, if you didn't send it 14 days in advance, or if the notice is missing any information, then obviously the owner can raise these issues as defenses, right? And subject the whole collection process to a successful legal challenge, and you don't want to do that. So when in doubt, seek the advice of your legal counsel, and maybe even have them prepare the notice of special assessment. Okay. Meetings of the board at which a quorum of the board is present has to be open to all owners, except, okay, there are two exceptions: meetings between the board and the association's attorney with respect to proposed or pending litigation, right? Those types of meetings can be closed. And then meetings held for the purpose of discussing personnel matters. Those can be closed. You would still notice the meeting appropriately as a board meeting, but you would indicate on that notice that the meeting is closed. As with membership meetings, owners are allowed to tape record and videotape meetings of the board of directors, subject to reasonable rules. And they're substantially similar to those that we identified in a few slides for membership meetings. Unit owners also have the right to speak at board meetings with reference to all designated agenda items. And this was also a new statutory requirement that took effect July 1st. They also have the right to ask questions relating to reports on status of construction or repair projects, the status of revenues and expenditures during current fiscal year, and other issues affecting the condominium. Just note also that the association can adopt written reasonable rules governing the frequency, the duration, and manner of member statements. That is allowed by statute. For board quorum, a majority of the board has to be present at the meeting in order to constitute a quorum. Board committee members can also attend and appear at meetings by telephone or video conference or virtually, Zoom or any other type of platform. And their attendance at meetings virtually will count towards quorum. Unless otherwise provided in the statute or in your governing documents, the action of a majority of the directors present at which a quorum has been attained will constitute the action of the board. There are certainly instances, and we'll talk about it in a moment when we discuss conflicts of interest, where you will need a higher vote of the board, right? 2/3. For example. So, but unless the statute requires a higher vote or you have a higher requirement in your governing documents, boards can approve action by a majority of quorum. Now, directors cannot vote by proxy or by secret ballot at board meetings. Generally, it's a verbal vote, right? With the one and only exception that directors can vote for officers by secret ballot. And Emily may have mentioned that when she talked about elections. Now, a director who abstains from voting on any action taken is presumed to have taken no position with regard to the action. But realistically, unless there's maybe a financial issue or financial conflict, really no director should be abstaining from voting. It is your function. It is your duty to vote and take action, right? So no director should be abstaining unless there's a conflict of interest. And then every vote and abstention for each director present at the meeting has to be reflected in the minutes. All right, committee meetings. For budgets and final action. A meeting of a committee that either takes final action on behalf of the board or makes recommendations to the board regarding budget, they are subject to the meeting notice requirement, right? There's no ifs, ands, or buts about this, right? You got to treat them just like a board meeting, and you've got to duly notice those meetings just like you would duly notice any board meeting. Now, if we're talking about meetings of a committee that do not take final action on behalf of the board, or that make recommendations to the board regarding budget, so in other words, any other type of committee meeting, the only way that they can be exempted from this mandatory notice requirement is if there is a provision in the bylaws that exempts these committee meetings from these formal notice requirements. That means you needed to have adopted an amendment to the bylaws, which requires membership approval. If you don't have this exemption in your bylaws, then pretty much all committee meetings have to be noticed in the way that a board meeting is noticed. Period. End of story. Insurance requirements. We're almost at the end, folks, so thanks for hanging in there. I think we have insurance and then conflicts of interest left. So 2 more topics. We should be able to get this done in the next 20 minutes. Maintaining adequate insurance. The association has to use its best efforts to obtain and maintain adequate insurance to protect the association property, the common element, and the condominium property that's required to be insured by the association. What is adequate property insurance? Well, the statute tells us that regardless of what your documents say as to the minimum coverage that you need to have, regardless of any requirements in the declaration for coverage by the association, the adequate property insurance has to be based on the replacement cost of the property to be insured as determined by an independent insurance appraiser. Okay, and this appraisal has to be done at least once every 36 months. So you've got to get this appraisal done, and your property insurance coverage is going to be based on that appraisal. There is an option under the statute to be quote unquote self-insured. I've never seen this done successfully. It is extremely complicated process to get that done. Virtually all associations in the state of Florida, maintain adequate insurance coverage. They're not self-insured. Now, in addition to, property insurance, you will want to definitely consider liability insurance for directors and officers. That's called directors and officers coverage, D&O. And then certainly there could be flood insurance for your area. So you will definitely want to discuss this with your insurance agent or broker. You also have to maintain fidelity coverage, right? Or fidelity bonding on any person who controls or disperses funds, association funds. And those can include anybody that signs checks, whether it's the president, secretary, treasurer, or really anyone, including your property manager, that will be handling association funds. The fidelity bond or insurance policy or fidelity insurance has to cover the maximum funds that will be in custody of the association or its management agent. And obviously the association has to pay for the cost of this fidelity bonding. Okay, it is a statutory requirement. It cannot be waived. You have to have it. So get with your insurance agent. Effective July 1st, if the division receives a complaint, the division will monitor an association for compliance with its statutory insurance requirements and may issue fines and penalties established by the division for failure of the association to maintain the required insurance policies. What are you required to insure? Well, the statute says that after January 1st of 2009, the association has to provide primary coverage for the 2 items identified here. All portions of condominium property as originally installed or replacement of like kind and quality. And then all alterations, additions made to the condominium property or association property. As of July 1st of 2010, the ability to force place owners coverage requirements were eliminated. That means that these items we've identified here in the second bullet point, the association's coverage excludes all of these items, which basically is the responsibility of the owners to maintain insurance on, right? So all personal property within the unit and limited common elements, floor, wall, ceiling, covering, appliances, water heaters, water filters, built-in cabinets, curtain drapes, blinds, window treatments. All of these items are the responsibility of a unit owner to maintain insurance on. But as of July 1st of 2010, the statute does not mandate owners to maintain this type of insurance, and you can't place coverage on unit owners. So you can't buy coverage and put it on a particular unit, right? There is potentially an option for association to require owners to maintain insurance coverage if you amend your declaration and include that requirement in the declaration, but I would caution you from doing that, and that's something you might want to discuss with your legal counsel as to whether or not that would be appropriate for your association. But just know that is an option, because there's nothing in the statute right now requiring owners to maintain this. Now, repairs after a casualty. So a casualty event is going to be, a sudden, unexpected event. For example, a hurricane, right? Or a sudden, unexpected pipe burst in the condominium building that floods a unit. So if any portion of the condominium property that must be insured by the association, if it is damaged by an insurable event that the insurance would cover, right, then it has to be reconstructed, replaced, or repaired by the association. Now, any portion of the condominium property for which the owner is required to maintain insurance, that would be the owner's responsibility. And then any portion of the condominium property that's not paid by the insurance proceeds, if it is damaged by the intentional conduct, negligence, or failure of a unit owner to comply, right? Well, and the association ends up, doing the repairs, well, the association can go after the owner to get reimbursement for those repairs, for the cost of those repairs. Now, the association is not obligated to pay for any reconstruction or repair expense due to property loss to any improvement that is installed by an owner or by the developer if the improvement benefits only the unit for which it was installed and is not part of a standard improvement installed by the developer in all units. So for example, where this typically comes up is if an owner installed tile on their balcony, right? And this was not something that was installed by the developer. This was something that it was an owner alteration, right? Only to their unit. And the balcony gets damaged, right? And you need to rip out the tile. The association is not responsible for that tile. Now, what we've talked about here is damage that results from a casualty event, right? Now, in the absence of an insurable event, right? So if there's damage that is caused other than an insurable event, right? So if it's done, for example, by an owner's negligence, failure to maintain something, then the association or unit owners are responsible for reconstruction, repair, replacement as determined by the maintenance provision of the declaration. So you'd have to look at the declaration to see who's responsible for what in that event. All right, and the final section is conflicts of interest. Just a few more slides and then we're done, folks. So directors, officers, and then relatives of these individuals have to disclose any activity that could be reasonably construed as a conflict of interest. And what is a conflict of interest? Well, there is a rebuttable presumption of a conflict of interest, that a conflict of interest exists if these two things exist. Either the director, officer, or relative enters into a contract with the association for goods or services, or director, officer, or relative, they have an interest in an entity that either provides services or is looking to enter into a contract to provide services or goods to the association. If those two things exist, that is considered, there's a rebuttable presumption that this is a conflict of interest, and it has to be disclosed. Now, the statute doesn't prohibit these transactions necessarily from being entered, but there is a process, there's a procedure that needs to be followed to properly approve a contract or a transaction that is subject to conflict of interest. The first thing is that a director or officer or a relative of a director or officer who proposes to engage in an activity that's a conflict of interest, okay, they have to be identified, as part of an agenda of the meeting at which this is going to be discussed. And then the contract, right, or any document that is associated with this proposed transaction also has to be attached to the notice agenda. Then at that board meeting, 2/3 of the directors who are present have to approve the proposed contract or transaction that is the subject of a conflict of interest. Now, the individual who is the subject of this conflict of interest can attend the meeting, which the activity is being considered by the board, and is allowed to make a presentation to the board, right? So if a director is has an interest in a corporation, in an entity that is looking to provide services to the association, let's say it's general contractor, right? And you're looking to provide services to the association, well, that director can be present at the meeting and can make a presentation. But then after the presentation, that individual has to leave the meeting while the board then discusses and considers the proposed contract or transaction that is a conflict of interest. Now, that director's officer's attendance at that meeting can be counted towards quorum. Even if the director later leaves, you've already established quorum, right? So that the rest of the board can now discuss and consider this contract or transaction. And then the director or officer who is a party or has an interest in this conflict of interest activity, they have to obviously recuse themselves and cannot vote on the proposed contract or the transaction. Now, if the board votes against the proposed activity, then the director or officer relative of these individuals has to notify the board in writing of their intent not to pursue the proposed activity, or they have to withdraw from office. They have to resign. Now, what most boards miss is this next step. Then at your next membership meeting, whether it's your annual meeting or your special membership meeting, at the next membership meeting, you have to disclose this conflict of interest to the owners. Okay? And then the owners, upon a motion of a member, may cancel this contract or transaction by a vote of the majority of the members who are present. So even though the board approved the transaction that is subject of a conflict of interest, owners have the ability to later disapprove or cancel that contract. And if the membership votes to cancel that contract, then the association would only be responsible for the cost of services or the cost of goods provided up to the time of termination, and would not be on the hook or liable for any termination fees or liquidated damages or any penalties for terminating the contract early. Now, if a contract has been entered between director, officer, or a relative and the association, right, there's a conflict of interest, and that contract has not been properly disclosed as a contract of interest, then that contract becomes voidable and it can be terminated by the board with the consent of at least 20% of the voting interest. And then any association that is currently subject to the website requirements has to post a copy of the contract on the association website. There is also a conflict of interest statute addressing community association managers and management firms. So any manager or management firm or any director, officer, persons with a financial interest in community association firm or any relatives of these individuals, they must also disclose to the board any activity that may reasonably be construed as a conflict of interest. And a conflict of interest, there's a rebuttable presumption that a conflict of interest exists if that property manager or that management firm or any of the directors, officers, or persons of interest with that management firm want to enter into a contract with the association, or if that manager, management firm, or any of the directors, officers, or persons of interest with that management firm have an interest in another entity that is looking to enter into a contract with the association. Okay, so again, very similar disclosure requirements. That transaction contract has to be disclosed at a board meeting. The disclosure has to be reflected in the minutes, and then it has to be approved by at least 2/3 of the directors present. Now, if the manager or management firm has previously disclosed this conflict of interest in an existing management contract that was entered between the association and management company, and sometimes management contracts do reflect entities that are associated with the management company that might be providing services. So if that disclosure is already in the management contract, then the conflict of interest does not need to be additionally noticed and voted during the term of the contract. But once that contract renews, then yes, you need to go through these disclosure and voting requirements to approve that transaction. If the property manager or the management company has violated the section, then the association may cancel its management contract. And if it cancels the contract, then it's only responsible for fees or costs of services, goods provided through the date of termination, and would not be subject to any liquidated damages or any termination fees. Now, failing to also disclose any conflict of interest constitutes grounds for which disciplinary action can also be taken against the property manager or management firm. All right, I think that's it. Yes.
Woo, mouthful.
We're at
well
the
done.
end.
Very well, very well. We have a
Everyone
little bit
survived.
of time. Yeah, gosh. We'll handle Kirsten's going to do a few questions. Not going to get to all of them. As I mentioned, there's a ton of you here, and we'll get to a few. But before she does that, I do want to mention that the link for the evaluation is in the chat. Hopefully you've all opened the chat area already. If you haven't, do that now. And I'm going to place the link in there again. Just did that. And when you click on that link, now the Q&A part, we want you to hang out. We want you to stay. We want you to listen, but this part is not required. So after you do the evaluation, if you need to get out of here, you can. That's okay. So after you click on that link, it's going to take you to this page here. This is the evaluation. I'm not going to go over it now. Kirsten's going to get to a little bit of Q&A. I'll go over it more slowly after the Q&A. You'll submit it. You'll get the confirmation screen of a successful submission. You don't have to ask me, hey, Jeff, hey, Kirsten, did you get my evaluation? After you submit it, if you see this screen, that means it's successful. If you see no error messages and you don't see the screen, that means you probably have a pop-up blocker or something on your browser. As long as you don't see any error messages, you should be good to go. And then you'll also notice that the fourth bullet has the link to download the slides. And the last thing you'll notice is that there's no certificate here. We email your certificate to you within a couple of days or so. after we cross-check the evaluation with the Zoom attendance sheet to make sure you were here for pretty much the entire time. If you're on the phone and don't see the link for the evaluation, don't worry about that either. I will be matching up the, if you just are here on audio only and don't see us, I will match up the phone numbers that you entered in registration with the attendance, and I'll email you the evaluation link that way. So don't worry about that. Barbara and Mike, click in the chat area, not here in the Q&A. Q&A and chat are two different areas. I'll go over that in a moment. Kerstin, back to you.
Man, lots of questions.
Yeah. And all of these are just from the second half only. So there's no way we're going to get to all of them. We'll do a few of them. The important thing is for this complimentary session, remember folks, this was complimentary. The attorneys they're very, very busy as well. And the important thing is to make sure we cover the required material for you. That's the most important thing.
Sure.
Back to you, Kerstin.
All right, what if an owner does not show to the hearing after receiving notice of the hearing? Well, I mean, the hearing is intended for their benefit, but if they don't show up, they don't show up. The committee can then still make a decision of whether or not they want to ratify the suspension or the fine. This individual is asking again if the two-story condos need to do any kind of inspection. Well, if you're referring to a milestone inspection, they apply to buildings 3 stories and higher. Okay, now, I don't know what county, municipality you're in, but for example, in Broward County, there's the 40-year certification requirements. I believe it's now more of a, I think they've done away with that and now just generally require inspections every 25 years. So bottom line is you're going to have to check with your, county municipality if they have any other specific inspection requirements for your buildings. So there's a question here, if they find someone and they fail to pay the fine, does this mean that the board can then suspend use rights for delinquencies? That's absolutely right, because that becomes a monetary obligation that is delinquent. So as long as they haven't paid for 90 days, you can go through the process of suspending use rights. You cannot fine for delinquency. You can only fine for covenant rule violations, which are unrelated to payment of assessments.
I'm gonna cut you off for a second while you're looking, Bruna. Yeah, this course, as we also mentioned at the beginning, this was for Condominium Association board members. So if your management company sent you this link and you're in an HOA, unfortunately, it is the incorrect class. Back to you.
This question here: how closely does the board have to follow the operating budget? How much may the board spend on items or services not included in the operating budget? Well, I mean, remember the budget is a as an estimate, right? It's not intended to be exact. But operating funds, if you're short on a specific line item in the operating section, you can certainly, use funds allocated for other line items within the operating budget to make up shortfall. If you have unanticipated expenses, as long as they are, bona fide association expenses, you could use operating funds. It's quite possible you may need to also adopt a special assessment to address any budget shortfall. So these are some options to consider. Let's see here. Let me go down a little. Well, there's a question here. If all meetings need to be scheduled over 14 days out, well, not sure if you're talking about membership meetings or board meetings. Not all. Board meetings, typically 48-hour posted notice, unless you're adopting a special assessment or adopting a rule. concerning unit use, in which case, yes, it's a 14-day notice. But you might have other notice requirements, more restrictive in the bylaw, so check those too. Does the affidavit have to be notarized or just signed by the person sending the notice? No, it does have to be notarized.
I have two other people that were in an HOA. Unfortunately, this is a condo class. And when you click on these links to register, be sure I know that sometimes it's very wordy, but before you get to the fields that you fill in, we have these disclaimers on there saying that if you're a board member for an HOA, this is not the class for you. So be sure you read all that print before registering for any of the courses. And for the inevitable questions we're going to get here about continuing education, we don't have that clarification just yet. So right now we're just doing the certification. Once we have that clarification, anytime we email anybody what's coming up, I will be sure that we have listed what the course satisfies for everybody. So you'll know exactly what you're getting into when it comes to continuing education.
Are there any penalties for not acting as written in the governing documents? Absolutely. It's a breach of fiduciary duty if the association, if the board does not enforce the covenants that are in the documents. So absolutely take a look at your documents, become familiar with them. And if there's certain covenants that the board feels that they're just, they haven't been enforced and want to enforce, then you're looking to probably amend your documents to remove them. But just know that, yeah, you can become subject to a potential division complaint or a lawsuit. So that's why we recommend that you maintain D&O insurance coverage, directors and officers insurance, in the event the association and the board ever gets sued. Let's see.
Manuel and others, yes, the required portion is done. So if you filled out your evaluation and you don't want to hang out for the last few questions Kirsten's going to answer, you can head out. Thanks for hanging out with us.
A lot of these are very specific, so it's hard to give guidance. I mean,
It is.
specific to a community. If a certified mail is certified mail required to notify the board that an owner would like a copy of a contract that will be considered any board meeting, or email suffice? With records inspection requests, there's nothing in the statute that requires the request to be sent certified. The board can adopt reasonable rules regarding records inspection. That could be a requirement, but if you don't currently have it, then I would say an email request for a copy of a contract or to inspect a contract would be a statutorily compliant request. Personnel meeting examples. Well, for example, if you are looking to hire, or if you're looking to fire, terminate any existing employee, or if you're looking to terminate your current property manager, that would be personnel matters. Let's see. Deny. Let me take a couple more. Man.
Yeah, while you're looking, I see somebody joined about an hour later. Unfortunately, you know, we have to have the timestamp showing you were here for the entire time should you ever get challenged. So unfortunately, you know, we need to make sure that you are here the entire time for anybody asking about that in the Q&A. If you came in a couple of minutes late, that's one thing, but an hour late, you know, unfortunately not.
I mean, someone's asking about amending the governing documents that are 50 years old. I mean, there's several options in doing that. And in fact, we do teach a course about you know, amending your governing documents. You know, I would say, you know, get in touch with your legal counsel. I mean, otherwise, certainly you can reach out to me and we can, you know, more personally address that issue over the phone. Okay, I think that's it.
Thank you, Kerstin. Wonderful job once again. We had a funny comment in here. You and I are both wearing sweaters, you being in South Florida, and she mentioned
Folks, it was like 40 something degrees this morning, at least here on the West Coast.
yeah, sunny
Tampa
South
area.
Florida. And for those of you who don't know me, when I'm not in South Florida, I'm in the Birmingham, Alabama area, so it's quite cold here right now.
It's
So Kerstin, you can reach Kerstin at
Yes.
info@kbrlegal.com. Also, her email address is khenze at kbrlegal.com. That information will appear after you submit your evaluation as well. Kerstin, you have any parting words before I take over and go over the techie stuff?
No, other than, you know, arm yourselves with competent, you know, experts or professionals who practice in this area. You know, engineers, accountants, and certainly attorneys. There are so many out there that don't really specialize in this area. Our firm is an exclusive community association law firm. Like this is
Right.
all we do 24/7. And I've been with the firm for 15 years and practicing close to 17 years. So, you know, protect yourselves, do yourselves a favor.
Kerstin, she started when she
Get
was 10,
competent.
by the way.
Thank you, thank you. I get offended when they don't card me. So, but thank you so much for bearing with us. I know this was a very long class, but you did it. So thank you so much.